Why don't you go see your boyfriend?
Yeah, he's got a nice room. He won't have it long. He left a call for 7 a.m.
See if we can figure out something.
Listen to us.
Hiya. Hey, Teresa. You were the first one here. I don't know why I've got these two little lines. I was cleaning my camera and I don't know what the situation is. I am streaming from bed today because I am just taking a short lunch break between focus things, and I'm so comfortable that I'm not getting distracted by my shoulders being sore, my neck being sore, etc. Yay! I think it reached you when you weren't in chat, maybe. Because I think it was last week. I haven't streamed this week at all, I don't think. I actually started off the week with a tummy bug, which was wonderful. I think it was kid germs, and those just knock me so damn hard. It's actually insane. I hope that he is doing well. I hope that everything went well. Give us an update if you can. So I mentioned in the comments last night that I will be doing Judge Middleton's contempt situation. It's edited and it's uploaded. I just haven't decided if I'm going to put it tonight or not. I think I might, because tomorrow in Judge Middleton's court is the rest of that landlord-tenant trial. So that is what we'll be watching tomorrow. The surgery was a success. Teresa, I'm so happy. Do I even have like it's a bit wah-wah, but it was the best I could think of at the moment. Hey, True Crime Kitty. Hey, Karen. Hey, Steve. Okay, let's start off with Judge Middleton. I was saying I'm comfortable, and yet I was just thinking I actually need to adjust my setup, get my lap desk sorted, etc. At some point, I'm also going to have to move you onto a different laptop, because one of the things I need to listen to a video, and it's going to be conflicting. I was still busy searching through these. There's got to be something. There's got to be something here a little more. What is this? No. Well, this works. But it's like the excited one. Hey, is it Q Jams? I am happy you made it live as well. Welcome, Karen. I am so glad you're here, and I hope that you stick around. Hey, Laura. So I was just mentioning, because I know you were in the Premier chat last night, Judge Middleton's contempt, I'll probably put as a Premier tonight. I was debating whether to do it or not because last night was Judge Middleton, and then tomorrow is Judge Middleton's trial, the end of that landlord-tenant. Note to self, Vicky Mac, I need to put those links in the description. So I didn't know if it was going to be a bit much to have it like 3 days in a row, but actually I want to watch that contempt thing tonight since it's ready to go. Hey Nancy. It is nice to see you here. Okay, let's watch some Judge Middleton. Let's grab this banner. Feels like it's been so long since I did this and it's only been like 4 days.
Then. So the first one that we will take is going to be position 9, Donald Gray. Bostic, you ready? Bostic. You're on mute, Bostic.
I am.
You ready?
I reckon so.
Okay then. All right. So it's position 9, Donald Gray. We got 24 PI 003 078 Donald Gray, 126 days without indictment. There's a $5,000 good bond as of June the 18th. Burglary in the first degree and theft by taking.
40 cycles, and he's on some old probations. One is mathematically it's from 08. It was a 20-year sentence for burglary. There's 1, 2, 3, 4 other felonies more than 10 years old, and then there's another old burglary from 2016. That was a 10-year sentence. 16 SC 144275 and 1 FTA in 2014. Nothing further.
All right. Go ahead, Ms. Steffo.
Your Honor, Mr. Gray has been in custody for 126 days on these charges. He is 54 years old and a lifelong resident of Atlanta. We are working to get him into housing right now and into a drug treatment program. He has been prematurely accepted into canine cellmates as long as we can get him housing as well as drug treatment. So we are asking for a bond reduction for a total amount of $2,000 on both charges so that we can find him bonding assistance.
All right. Go ahead, Ms. Morrow. Go ahead. What says the state?
Yes, Your Honor. The state would ask for the bond to remain as set. I do just a quick pull of his name in Odyssey. I saw multiple arrests for theft related charges, burglary, entering autos. So he does present a very significant risk of reoffending. So the state will be recommending the bond remain as set given his history.
All right. All right, so we have no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 275 10th Street. No further contact with Neil, Neal Patel, common spelling, and no further contact with your alleged co-defendant, James Crooks, Crooks. Let me see. I already said no drugs, no alcohol. Let me make sure. And stay out of Midtown. So you got to know where the Midtown area is in Atlanta and stay out of Midtown, sir. So what I'll do right now is let's see. 2,000 and 1,500. Best of luck to you, sir. They should be able to do that, right, Ms. Steffo?
I believe so, Judge. Thank you.
All right. Well, have a good time at the baseball game. Think about the rest of us.
And Your
I've
Honor,
got one more, Mr. Thomas.
sorry, Judge, just to put on the record, I'm not sure whether this was heard at the last hearing, but we were able to get in contact with the victim, and the victim stated that they were fearful of the defendant. So just for the record.
Is that Donald Gray?
This was, I'm not sure, Judge.
You don't know which case? That's okay.
I'm not sure which victim. Hold on.
No, is it the Donald Gray case?
Yes, Judge. Yes.
Oh, okay. So stay out of Midtown, sir. I tell you what, sir, when you get out of there, you'll have a 24-hour curfew, court lawyer, medical, and participation in that program. That's the only reason you leave. All right. Best of luck to you, sir. All right. Thank you, Ms. Steffo. That's it.
No, Judge, I have one more case. I have Mr. Jamal Thomas.
Thomas. Jamal Thomas, are you here?
I do not see him.
All right. As soon as you see him, because he will be in 6 North. As soon as you see him, if you see him, let me know, okay?
Okay, thank you, Judge.
All right. Wakila Tucker, position 1 on the add-on Bostic, 24 PI 003 876, 99 days without indictment, $15,000 good bond as of May the 31st. Got aggravated assault and battery. Looks like it's alleged stabbed, stabbed victim where he lives.
24 cycle of old theft by receiving 2017 ag assault, family violence, 2 counts, battery, family violence in 2020, FTA in 2020, nothing further.
All right. Go ahead. Is Ms. Murray here? Yep. Go ahead, Ms. Murray.
Thank you, Your Honor. Ms. Tucker has been in custody 105 days. She is 46 years old. She's a lifelong Georgia resident. She has plenty of family here, aunts, uncles, her mother. She also has 4 children that live here and 3 grandchildren plus 1 on the way. She does have a good address residing in Atlanta. Due to her being disabled, she does not she's not doing full-time employment. However, prior to her arrest, she did have a job lined up working at a senior citizens home. Ms. Tucker has been accepted into Women on the Rise. And as you'll see, Ms. Browning from Women on the Rise is here today in support of Ms. Tucker. We're hoping to get her bond lowered so that she can participate in some of their programming. I also did receive several calls from the alleged victim in this case. And he stated that he was not interested in seeing this case move forward. So we would ask that the bond be reduced significantly to give Ms. Tucker a chance to participate in Women on the Rise. We're going to ask that on the aggravated assault, given that it was with a knife and not a firearm, that be reduced to $2,500, and for the battery, that be reduced to $1,000.
So she's not going to live at 433 Camrose Way, right?
No, Your Honor.
All right. What says the state?
Your Honor, the state would be opposed to the bond being lower at this point. I did see a 2018 ag assault conviction in this defendant's history. So she does present a risk of reoffending. Our office hasn't heard from the victim, but it is the state's case at this point. So we are proceeding with this case. So we would ask that the bond remain as set.
All right. We got no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. You have a 24-hour curfew, ma'am, court, lawyer, medical, and participation in the Women on the Rise program. You also have to supply an address where you're going to be living and keep it updated. Let's see. No further contact with Henry Fitzpatrick. Stay away from 433 Camrose, Camrose Way Northwest in Atlanta, Georgia. I'll do 8,000 and 3,000. Best of luck to you, ma'am.
Thank you, Your Honor. And that concludes my business for today. May I be excused?
Yes, ma'am. Have a good weekend because I'm going on a vacation. I'll see you Tuesday.
Oh, lovely. Enjoy.
Thank you. All right, Ms. Steffo. So Jamal Thomas, is that you? Wave your hand. All right, thank you, sir. All right, we got position 4, Bostic, 24 PI 000515, 230 days without indictment. I've got a $55,000 good bond as of June the 21st. Armed robbery, battery, possession of a knife or a firearm during the commission of a felony, and possession of firearm by a convicted felon.
18 arrests in Louisiana, 5 in Texas, 4 in Georgia. Assault, bodily injury, family member in 2017, evading arrest in Texas. Open case 24 SC 003245, firearm by 2 counts obstruction, purchase, manufacture, and sale firearm during FTA in 24 on probation, firearm by 2/12/24, 22 SC 183000, 2/12/24, 3 years, nothing further.
This is number 4, Mr. Malcolm. I don't know which
Thank you.
one of you going to.
Appreciate it.
All right. Go ahead, Ms. Stefo.
Yes, Your Honor, Mr. Thomas is 40 years old. He's been in Atlanta for the last 5 years. He does have some cousins and aunts here. He has 3 children, a 12-year-old, a 14-year-old, and a 16-year-old who's to on the phone regularly while he's been in custody. He does have his GED and is a certified electrician. He's been working with D-Best Electrical Service for the last 6 years and would be able to go back. He does have a stable address here on Sunset Avenue where he's lived for about 5 years that he's been here with his cousin. And I have confirmed he would be able to go back. We are asking for a significant reduction in this case, given the fact that he's been in custody for 230 days without indictment. I would ask that all the charges get granted a bond of $10,000, Your Honor.
So I'll give you, you can respond to this. So this incident date was allegedly 12/27/23. And he had bond conditions, no weapons, no replicas of weapons. However, on 1/19/24, he was arrested for possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon. So that kind of worries me.
Yes, Your Honor. It's my understanding that those cases, he got arrested on that case, the one that just recently got indicted. And when he got arrested for that case, this warrant popped up. So it wasn't that he was given the bond conditions and then violated them. He was just arrested while this warrant was already out.
All right. Go ahead, Mr. Malcolm.
And what is his bond now? It says 56,000, but it's
55.
55,000. State would ask for a $50,000 bond, please.
All right. We got no, is he going to live in the metro area?
Yes, Your Honor. He's going to be living at Sunset Avenue, Northwest Atlanta, Georgia.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1021 Fair Street Southwest in Atlanta, Georgia. Also, no further contact with Tovar, Tovar Gordon, Gorden. So we'll do 25,000, 4,000, 8,000, and 8,000. 25,000, 4,000, 8,000, and 8,000. Now we'll put him
Your
on.
Honor, I apologize. If I may, it does say on his jail screening that his armed robbery is set at 3,000, his battery is set at 5,000, possession of a firearm is set at 10,000, and then possession of a firearm by a convicted felon is set at 10,000.
So I'm just looking at a copy of the bond order. So that must be something because it's 30 and 5, then 10, then 10.
Okay, I think they just misput it in the system.
Yes, ma'am. So best of luck to you, sir. You can lead the booth.
And Judge, that concludes my business. May I be excused now?
Ma'am, enjoy the ball game.
Thank you. Have a good one. Have a good vacation.
Thank you.
Your
Let's
Honor,
see.
my business is concluded as well. May I be excused?
Yes, ma'am. Have a good evening.
You too.
Thank you, ADA Salary, for filling in for me. Appreciate it. Judge, I apologize for being late. Court ran late this afternoon.
Imagine that.
I know it.
All right. Do we have Anthony Washington? Wave your hand. All right, Mr. Washington. All right, Mr. Dobbs, we got position 8, Bostic 24 PI 003739, 103 days without indictment, paid to register, and there's a $1,000 good bond on June the 14th. Wow.
8 cycles of meth in 2018, meth, cocaine obstruction, 2018, controlled purchase manufacturing, 07, terror, robbery, kidnapping, 2 counts, armed robbery, burglary, CWAC from the 90s.
All right. Go ahead, Mr. Dobbs.
Thank you, Judge. Full disclosure for the state and the court, the bond that is currently set is the result of a consent bond that I came to with the state in court. My conversations with my client indicated that he would be able to make this bond, but he has not. I apologize for coming back on this, but you know, when people are in jail, they don't always have the best access to information of what they can and cannot make. This is the amount where we could get bail assistance. The problem is Mr. Washington has a hold, so a foreign county hold. So I've contacted the Georgia Justice Project, who can sometimes clear those up if somebody's been in long enough. Haven't heard back on those. I'm not sure what's going to happen with that. Mr. Washington is 45 years old. He's actually 46 years old now. He turned 46 in jail. He has a fixed address on Austell Road in Austell, Georgia, in Cobb County. He resides there with various family members. I think his mom and his aunt. He's a lifelong resident of the state of Georgia. He is a high school graduate. At the time of his arrest, he was working for HireQuest. That's a temp service. He's confident that he can return to to higher quest. Judge, hearing his history, pretty much all, I think all of the violent history, I think the underlying charge, which is the reason for this charge, is all in the 90s. I would like the court to take note of that. Mr. Washington has not been accused of anything violent or CWAC in quite a while, since I was a small child. So I just want the court to keep that in mind. He has strong ties to the area. I
Thank you so much, Laura.
apologize for coming back on a consent bond, but it is what is necessary at this point. Mr. Washington has been in jail for 103 days as a legally innocent person, not able to assert defenses because his case has not been indicted. For those reasons, Judge, I'm asking for a reduction on the bond to $300 and a conversion to the sheriff's 10% program. Thank you.
So he couldn't make the sheriff's 10% program at 1,000?
He could not, no. And the hold prevents me from seeking bail assistance. I'm waiting on the Georgia Justice Project.
All right, I got you. Go ahead, Mr. Malkin.
Well, can we reduce it to 700 or 800?
Mr. Dobbs.
I'm going to stick with my initial recommendation of 300. But of course, we appreciate the state offering to come down on this bond. We would appreciate any reduction, but given the amount of time he's been in, given that there's no violent history since the 90s or CWAC since the 90s, I'm going to ask for that $300 through the sheriff's 10% program. Thank you.
Mr. Washington, thumbs up or thumbs down? Can somebody come up with like $70? No? You ain't got no family. No, I can't hear you. You ain't got no family that's got $70. Mr. Malkin.
Where is his hold from?
It is from Douglas County.
Okay.
I'm working on trying to get something done with it.
Yeah. I guess we can do a release to the hold and then require him to report within 48 hours.
I would love that.
Can you do that with a violation though?
Not sure.
I don't believe that this charge is bail restricted. If your honor would give me a moment to verify that.
Okay.
And I'm sorry to take up the court's time.
Bostic, is it? Bostic usually knows him.
Bostic
I
does
don't
know.
recall that being on there.
Okay.
I'm almost positive that it's not.
All right.
Thank you, ADA Malkin.
All right. So here's what we can do. We'll, Mr. Dukes, you remember how to do this. So we'll do $300 through the 10% program or a signature bond to the whole.
And I'll prepare, should I prepare some sort of transport thing or something for that?
Sure. Yeah, you can send it to me.
Okay, I'll prepare a transport order to the Douglas County Sheriff's Department.
Right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. You must register within 24 hours of being released. So if you got to go to Douglas, and stay out of Fulton County. The only reason you come back to Fulton County is quarter to see your lawyer. All right. So it'll be $300 through the 10%, or in case the hold says I don't know what the hold's for exactly. So if they don't come pick you up, you can at least still make bond. All right. Best of luck to you, sir. You can leave the booth.
And Mr. Washington, I'm going to prepare that transport order for the judge's signature this evening. Thank you, sir.
All right. Do we have Colby Walding? Wave your hand. Everybody's on mute, so you got to wave your hand. There we go. Outstanding. It's position 10, and it was transferred up. So it's 24 PI 005648. And I didn't even write down how long they've been in jail. I'm slacking. I think it's been a minute, but there was a $3,000 bond through pretrial, but I think pretrial came off of it in March. So right now you're at no bond, and it is a felony obstruction of a police officer.
It's 238 days, Your Honor.
Thank you. 238.
It's 3 cycles. No prior felony arrest, misdemeanor conviction, theft by taking, and criminal trespass this year. Nothing further.
All right. Go ahead, counsel.
Thank you, Your Honor. Mr. Walding is 24 years old. He is originally from Mississippi, and he actually was arrested while he was traveling from Tennessee back home to Mississippi. So he actually does not really have any connections here to Atlanta or the state of Georgia at all. Your Honor, he has become homeless as a result of his extended stay here at Rice Street. Your Honor, he's been in since January. He was a ward of the state of Mississippi and was raised in foster care. He has a brother and sister who are now located in Tennessee and South Carolina, respectively. But it was Mr. Walding's plan to return to Mississippi, where he has some connections to help get him reintegrated into society, Your Honor. So at this time, he doesn't have any money to make any kind of bond. I will be reaching out to his family, but this one was an upgrade from misdemeanor. And I guess there was some, this one slipped through the cracks that he wasn't able to get a court date or anything up until this point to have this addressed. He did, I think, have some kind of bond through pretrial, and then he was arrested in January, and pretrial came off that bond. And of course, since July 1st, this felony obstruction charge is now a bail restricted offense. So, Your Honor, he's been in over 250 days at this point. We'd be asking for as low of a bond as possible. Hopefully something, maybe $100 for the sheriff's 10% program or something that can be worked out that way, so that Mr. Walding can be released. He does have a hold, I believe, out of Mississippi, and he would be happy to go and deal with that there. Your Honor, and to be frank, I also have not been able to locate the warrant specifically for this one, so I'm not sure the reason for the upgrade.
But it says he punched officer, was it Hammonds, in the face. I know I had to, because you don't have access to the state court thing, but I've got it and I looked it up.
Understood. Thank you, Your Honor. I figured it was something along those lines, but just wanted to make it clear what's been going on our end so far up to this point. So. Once again, we'd be asking for a bond as low as possible at this point, $100 through the sheriff's 10% program, or at the very least, something that we would be able to go to the bail project and work out some kind of release for Mr. Walding, because he doesn't have any help here. He doesn't have any connections, and he doesn't have even a penny. He would not be able to make a $1 bond on his own.
So just let me ask you a quick question. So his brother and sister live in Tennessee, but he's going to go to Mississippi where his brother and sister doesn't live.
Correct. It's where he's originally from, and he still has some connections due to his time living in foster care there. His brother and his sister both are older than him, I think significantly older, and have children and families. He was staying with his brother for a short amount of time, but his brother said that he wouldn't be able to stay there long term. And so it was his intent to get on a Greyhound and go back to Mississippi. He missed the transfer here in Atlanta and unfortunately got into a little bit of trouble. And now it has been about 9 months that he's been trying to get home.
All right, so sir, just thumbs up or thumbs down. Did you sign yourself out of care before you were
I don't know if you heard that.
older?
It's 3 p.
No? So you were still in care as an adult? Okay. So you got that extra stuff that's provided by the juvenile court, correct? Where they help you find housing and stuff like that? You think so? Okay. All right. Go ahead, Mr. Malkin.
The state requests a $5,000 bond.
All right. So it's no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. I think Officer Earl Hammonds, no further contact no further contact and no further violent contact with any other law enforcement officer. You must provide an address where you'll be living. Because if not, sir, and you don't have an address, a notice is going to be sent out. And if you don't keep in touch with your lawyer, you're going to miss court bench warrant. It's just going to be a horrible spiral into a black hole. So stay out of the state of Georgia and Fulton County unless you're here for court or to see your lawyer. So the only reason you come back to the state of Georgia or Fulton County if you're getting a bus and taking it here for court or to see your lawyer. All right. Yeah, have to provide an address where you're living and keep that updated. So we'll do a $5,000 good bond, and it can go through there or the 10% program. Best of luck to you, sir. You can leave the booth. Okay.
And Your Honor, that concludes my business. If I may be excused.
Yes, sir. Have a good evening. All
Thank
right.
you as well.
So I've got Winfred Sherman. All right. Position 6, Bostic 24 PI 003901, 104 days without indictment, $40,000 good bond as of July the 12th on aggravated assault and possession of firearm by a convicted felon. Right.
22 cycles history of probation violation, old ag assault weapon with a deadly weapon firearm by old controlled substance, 2010 simple battery, and old false imprisonment simple battery. So the most recent is the 2010 simple battery family violence. Nothing further.
Mr. Malkin or Ms. Rose, do y'all know if there's been any contact with the victim before Mr. Dobbs? Because it says the victim was shot in the right leg. I'm just curious if there's been any contact.
No, Your
All right, so go ahead, Mr. Dobbs.
Thank you, Judge.
Honor, a victim locate was sent out.
Okay, go ahead, Mr. Dobbs.
Mr. Winford is 42 years old. He has a fixed address on Abner Terrace, where he resides with his three children and their mother. He's a lifelong resident of the Atlanta area. His only income is through SSDI because he was hit by a car and has rod and screws in his leg. He's prescribed painkillers, which he takes for that. He attended Carver and Douglas high schools, both local. I believe from the pretrial report. We didn't hear any FTAs indicating that Mr. Winford is overall going to come into court. Of course, that is one of the primary purposes of bond. Mr. Winford is legally innocent of these accusations. He's been in jail for 104 days. That's 104 days as a legally innocent person. He's not been able to fully assert his defenses because his case has not been moved forward by the state. Given the ties to the area, Judge, given how much time he has been in jail. For those reasons, Judge, we're asking for a bond of $25,000. Aggregate bond of $25,000. I understand that is a significant reduction, but my position is that the state has had ample time to indict this matter under the current bond. Thank you.
All right, is he going to live in Fulton County?
Abner, let me look at Abner Terrace real fast. I think that is in Fulton County. Let me just please check.
You gonna live in Fulton County, sir? Thumbs up or thumbs down?
It is, Judge.
Okay.
It is in Fulton County. It's northwest.
All right. Go ahead, Mr. Malkin.
Thank you. He's not been in custody all that long, considering a lot of the cases that we've seen. He does have a history of aggravated assault with a firearm, conviction for that. And in this case, he's accused of shooting somebody. So the state believes he does pose a significant danger to the community as well as reoffending. And the state would request a $38,000 bond.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Make sure you supply an address where you live. And also keep the court and your lawyer advised of where that is. Stay away from 2656 Donnelly Hollowell Parkway Northwest in Atlanta, Georgia. No further contact with Darnell, Darnell Green, Green. Also, sir, you're going to have a 24-hour curfew. Court, lawyer, medical, well, you don't work. So court, medical, and employment. That's the only reason you leave your house. Court, medical, or employment. So we'll make it, let's see.
Legal, can I get attorney meetings?
I didn't say, yeah, and just meet with your lawyer.
Thank you.
All right. And to meet with your lawyer. Sorry about that. So we'll do 25,000 and 5,000. Best of luck to you, sir.
Thank you, Judge. That concludes my business. May I please be excused?
Good morning, everyone. The 14th District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. Everyone, please make sure that you wait until your attorney has placed their name and appearance on the record, and then after that, please state your name. Mr. Jerome Barney, which case are you here on, sir? You need to unmute, sir. You need to unmute, sir.
Your Honor, I'm here on Zabian Prester.
Thank you so much. The court will. Yeah. Zabian Prester is not on the document. Okay, one moment. How do you spell that last name, sir?
It's spelled Prester.
And you spell Xavion how?
Zayion.
Okay.
Thank you, Laura. It's so kind. And that went to Nicola Maxwell.
We're not finding that. Do you have a case number, sir?
Case number is 24F as in Frank 5-5623 FD.
Sounds like a 15th District Court case. Correct. You need to be in the FIP. Well, let me see if we can find it, but that's not our court case, sir. That's 15th District Court. You're in the 14B.
Your Honor, he has a probable cause conference scheduled for this morning at 9 a.m.
Okay, you have a probable cause conference scheduled, and it's going to be out at the service center. So that's not this court, sir.
Okay.
So you need to call the 14A1 court. They can give you the Zoom information over there.
Pardon me, what was that, 14A1?
14A1, correct.
Thank you, Your Honor.
You're welcome. The court will call the case of the state of Michigan versus Eric Graham, also known as Terrence Watkins, case number 95S00027.
Good morning. It's here, Rachel McDuffie for the people.
Good morning, Ms. McDuffie. All right, this is a public defender case. Is anyone from the public defender?
Good morning, Your Honor. Assistant Public Defender Davy Leba on behalf of Mr. Graham, and I'm filling in for Ms. Muller today.
All right, thank you.
Graham?
For her for the whole day today, is that what you're saying?
That would be correct, Your Honor.
Yeah. All right. Mr. Graham, can you please state your name?
Yes, Eric Graham, ERICGRAHAM.
We're here for a pretrial today.
Correct.
That is correct. That is correct. Your Honor, my understanding is that Ms. McDuffie is going to be adjourning to look into some issues regarding identification in this matter.
That's correct, Your Honor.
Pretrial in this matter, how long do you need, Ms. McDuffie?
Just a couple weeks, Your Honor.
Actually, I'm gonna give it to October 10th. October 10th, 2024 at 9 a.m. Bond is continued.
Thank you, Your Honor.
Thank you. State of Michigan versus Russell Smith, case number 21S395085.
Rachel McDuffie for the people.
Russell Smith.
Thank you. Mr. Lebo, this is once again your case.
Yes, Your Honor. I believe this would be Mr. Mansauer's case where I can jump in. Mr. Smith has cleared up his outstanding tickets and fines. He is just waiting to take his driver's test and be requesting a final attendance.
I do have that scheduled for later today, Your Honor, as well. So
Okay, thank you for that info, sir. I'll bring you back on October 10th, 2024 at 10 a.m. You should have your license by then. I'm sorry, 9 a.m. You should have your license by then, I imagine.
Yeah.
You're all set. For the record, it does show that everything is all set up. He just shows us canceled. So we have to go get it reinstated.
Excellent, thank you.
State of Michigan versus Sammy Abdelatif, case number 23S00844, as well as 23S4320235.
Rachel McDuffie for the people.
Thank you. Good morning, Your Honor. This is Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Abdelatif, who appears today via Zoom. Mr. Abdelatif, can you state your name for the record, please?
Sammy Abdelatif.
Thank you. All right, we're here for pre-trials and pre-hearing conference today.
That is correct, Your Honor. I have spoke with Ms. McDuffie about an offer, and we are ready to proceed on that offer.
Thank you. Ms. McDuffie, the offer, please.
Which is that Mr. Abdelatif can, he will be pleading his charge to the DWLS, but he can have the civil infraction, so no proof of insurance for the count 2 misdemeanor. And he also has an equipment civil infraction. He'll be admitting responsibility to that as well.
I'm just writing it up. All right, let me make sure I understand. Defendant is to plead to count 1, driving while license suspended as charged, and an added count 3 of no proof of insurance. Count 2 will be dismissed. He'll also admit responsibility for the civil infraction and ticket number 23S4320235 of equipment violation. Is that correct?
That's correct, Your Honor.
That's correct, Your Honor.
Thank you. Is that your understanding of the agreement, Mr. Abdelatif?
Yes, Your Honor.
All right, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. All right. It is my understanding, sir, that, well, first of all, I'm gonna go over some rights that you have, and if you have any questions, please stop me. If you want to speak to your attorney again, also please stop me, okay?
Okay.
You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. And you have the right to be a witness for yourself, or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, Your Honor.
You understand you're going to be giving up all those rights and you're not going to be having a trial of any sort?
Yes.
You also understand that you have no automatic right to appeal this decision if you enter into this plea. Do you understand that part?
Yes.
And do you also understand that if you're on probation, parole, or bond, on the date that this offense occurred on December the 24th of 2023, then you could be in violation of that probation, parole, or bond.
Yes.
And were you on any of those?
Yes, I'm on probation with another court.
And you had an adequate opportunity to talk to your attorney about that and how it might be a violation? Were you on it on that probation on that day, sir?
Correct. I started August last year and I'm still on probation.
Okay. And have you had an adequate opportunity to talk to your attorney about that?
Yes.
Okay. And you still want to proceed, correct?
Correct. Yeah.
All right. And if you're not a U.S. citizen, you could have immigration consequences. Are you a U.S. citizen, sir?
Yes.
All right. The charge of driving while license suspended is a misdemeanor carrying a maximum penalty of up to 93 days and or $500 fine. And then the other two tickets are civil infractions. So with respect to the driving while license suspended, how do you plead, sir?
Guilty.
Has anyone promised you anything other than what we placed on the record to get you to plead guilty?
No.
Anyone threaten you in any way, shape, or form, sir?
No.
All right. On or about December the 24th of 2023, were you operating a motor vehicle at the vicinity of eastbound Textile Road and Tuttle Hill here in Ypsilanti Township, sir?
Yes.
And while you were operating that motor vehicle, sir, was your license suspended, revoked, or denied?
Yes.
Which one?
Suspended.
Suspended, okay. And the vehicle you were driving, did you have no proof of insurance on you at that time, sir? You admit that? And you accept responsibility for a defective equipment ticket, failure to maintain ticket on that same day?
Yes.
All right. I find that there's a factual basis for the pleas. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Mr. Mansour?
Yes, Your Honor.
Thank you. Are you requesting a referral in this matter, Ms. McDuffie, or where are we?
I am not, Your Honor. No objection, immediate sentencing.
All right. Mr. Mansour, anything you want to say on behalf of your client?
No, Your Honor. Thank you.
Anything you want to say on your own behalf today, Mr. Abdulatif?
No, Your Honor.
Fines and costs in this particular case for a total of $425 for the driving while license suspended. And given the other tickets, I'm actually going to make that $325. And then the no proof of insurance is $155. That's set by the state. And then the equipment violation, one moment. Gotta look that one up. Is $120. Can you pay that today, sir?
No, I would need a payment plan.
All right, how much can you pay per month and on what day, sir?
I believe by October 10th, I'll have all that paid off. October 10th.
So you think you can pay all this off in a month?
Yes.
Is it October 10th in the earlier part of the day or October 10th in the latter part of the day?
We could early part of the day.
You know what? I'll just do it this way. I'm going to bring you back on October 24th, 2024 at 10 o'clock a.m. Okay? If you pay, then you don't have to be here.
Okay, perfect.
And count 2 is dismissed, sir. Okay?
Okay, thank you, Your Honor.
You're all set, sir. Have a good day. You're welcome.
You as well. Thank you.
Mr. Mansour, it's nice to meet you, sir.
You as well, Your Honor. Thank you.
State of Michigan versus Hunter Range, case number 20S00581.
Rachel McDuffie for the people.
Mr. Hunter Range, could you please state your name for me? You need to unmute, sir.
Hunter Range, Your Honor.
All right, please turn on your camera for me also.
I'm
There you go. Thank you, sir.
okay. All right.
All right, Mr. Hunter Range, it appears that you never filled out a form requesting appointment of an attorney. Are you planning to hire your own attorney, or are you needing the public defender appointed?
I was gonna go with the court appointed.
Thank you. Give me one moment while I fill out the form to some degree anyway.
Thank you.
You still on Capri Drive, sir?
I am not.
All right, you're gonna need to change your address with the courts. Do you know how to use the chat feature, sir?
Ma-
Okay, I'm gonna request that the PD be appointed, or I'm gonna send this over to appointing authority so they can appoint you an attorney, sir. We are not able to proceed with the case today because there was no attorney appointed at the.
I represent myself today. That's okay. I'm just pleading not guilty.
Okay, thank you. You'll be back here on October 10th, 2024 at 9 a.m. Okay, sir?
Okay, thank you.
And then at that time, you should have counsel. They'll reach out to you at least a couple days beforehand, okay?
Okay, thank you, Miss Honor.
Thank you. Have a good, what's up?
Can he go into a breakout room if Mr. Willie works in order to get his address, or else he won't get the notice?
Okay, we're gonna put you into a breakout room with Mr. Willie Works, who can get your address and contact info from you, okay?
Okay.
All right, thank you, sir.
All right.
State of Michigan versus Mubarak Mosib, case number 24S4 321387.
Rachel McDuffie for the people.
Assistant Public Defender Davia Lebo from Mr. Mazab. Mr. Mazab, please state your name, sir.
My name is Mubarak Mozeb.
Thank you, Mr. Mosib. Sorry for the mispronunciation.
Yeah, no worries.
All right. We're here on a pretrial today.
Yes, Your Honor, we had previously adjourned because I believe Mr. Moseb had submitted his appeal to the Secretary of State and he was just waiting on the result. And it sounds like he's still waiting on that.
That is correct.
So if the court will permit him to adjourn, I would have no objection while he's waiting on that response.
And that is our request today, Your Honor.
And the hearing has been held, right?
Is that correct, Mr. Mazab? That's my understanding.
Yes, the hearing. Yes, the hearing was held on July 11th, and I'm still currently waiting. It is currently on the Hertz status for the case.
All right, thank you.
My pleasure.
We have a date in early November, November 7th, maybe. Okay. November 7th, 2024 at 9 a.m., sir. We'll see you back then. Hopefully you have a result.
Thank you, Your Honor.
Thank you, sir. Have a good day.
You as well.
State of Michigan versus Nicholas Twardos, case number 22S00836.
Heard from the deputy for the people.
Assistant Public Defender Davi Liba for Mr. Twardos. Mr. Twardos, please state your name, sir.
Nicholas Tordos.
Thank you. Good morning, Mr. Twardos. We're here for a pre-trial. I said the last adjournment was the last adjournment.
Yes, Your Honor. Unfortunately, we're going to be asking the court to reconsider that. Unfortunately, it seems that we need to get some more information on this case, including from the client. Additionally, we've been advised that there isn't an offer in this matter. So we do need a little bit more time to discuss this. I would not be asking for further adjournment after this one, however.
I do want to clarify, it's not that council just learned that there wasn't an offer, but previously we had adjourned a few times because the only potential offer in this case was that if Mr. Twardos were to graduate from recovery court, the controlled substance use count would have been dismissed. And so it is my understanding from Ms. Moeller yesterday that he has no interest in that. And so, but it was clear from, I think, the beginning that was the only potential offer. So obviously none would apply. And there have been no referrals to recovery court, and I don't think that he ever wanted to participate.
That's correct. My understanding, Mr. Twardos is not interested in that option.
I'm not even sure what recovery court is. I was told I would be discussed that further once they contacted me again, but I don't know what recovery court even is about.
Mr. Twardos, I'll give you a call after court today and we can discuss it.
Or I'm just saying, I haven't heard from
I don't know how
anybody.
he can reject something that he doesn't even understand what it is. That's the first thing. And his consequences could be very severe for rejection, not just in terms of the plea and that issue, but in terms of the potential sentence.
Yes, Your Honor.
And understood, Your Honor. I'm just relaying that Ms. White had previously adjourned twice to discuss it with him and to potentially get the paperwork started. It sounds like that didn't happen at that point. And then Ms. Moeller conveyed to me last night that Mr. Twardos didn't have any interest in it. I can only assume that she assumed that based on some conversation they had, but that's all I was told.
Well, I'm curious how it would work. I'm on a Suboxone program and I've been on one for the last 6 years. So I'm just curious how that would work with this treatment court.
Thank you. Well, sir, we've definitely worked with people who are on Suboxone. That's a part of what we do, but you'll have to talk to your attorneys in more detail about that. Have you tried calling them directly?
I have, up until yesterday, I haven't heard from a single attorney, and I had no idea who the last one was. Nobody's ever called me until last night.
Put this over to October 10th, 2024 at 9 a.m. At that time, sir, I'll be asking you again whether you've had an opportunity to speak with your counsel regarding what recovery court is and whether you have a full understanding. It is my suggestion that Mr. Twardos be given a full opportunity to understand what that programming is and that he be given opportunity to talk to Mr. Reyes, at least so that Mr. Reyes can fully inform him on that before it is foreclosed as an option in this particular case.
Certainly, Your Honor.
Thank you. Bond is continued.
Thank you.
State of Michigan versus Kimmy Johnson, 24S436275 A and B.
Rachel Meek, for the people.
And Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Johnson, who appears today via Zoom. Kenny, can you state your name for the record, please? You gotta unmute first, if you can.
Kenny Johnson.
Thank you. All right, we're here for a pretrial and a pre-hearing conference.
That is correct, Your Honor, and I was going to request an adjournment here. Mr. Johnson is paying His outstanding tickets, he has 2 tickets left. And I believe he should be able to get those tickets paid off in about a month. Then he should be in position to get his license fully restored.
All right. I'll see him back here on November 14th, 2024 at 9 a.m. That should give him time to get his tickets paid off and get to the Secretary of State.
Okay, sounds great. Sounds great.
Bond is continued, sir. We'll see you here then, okay?
Okay, thank you. Have a good night.
Thank you. You too.
How do you end that?
Okay, we have to pause here. Emergency bond
State
hearing.
of Michigan versus Princess
Judge
Willis,
Middleton.
case number 24S001.
Paul, does she just want to plead guilty today?
I could ask her if,
I
if
could put you in a breakout room, Paul, if you need to.
She can have time served, do the statutory dismissal, so she'd come back for sentencing and be placed on probation.
Okay. She
All
might
right,
do
so
that.
we're gonna go on the record this morning. Let me go on the record. We've had a bit of a disjointed morning. We've done an expungement hearing. Judge Pattison is back and he took his own arraignments this morning. There was only one. And there was a pretrial and that defendant isn't here. Anyway, we've got an emergency bond hearing we're about to do, and then we've got a few things this afternoon. We're going to be doing some employee interviews, so we've kind of blocked the calendar out. So let's get to work here. Good morning.
Good morning.
This is Judge Middleton. I'm here at the court. You are Annette Louise Holderman, and this file number is 241601. Your attorney, Mr. Paul Gibson, has filed an emergency request for a bond reduction. Also present is Mr. Joshua Robert, the Chief Assistant Prosecuting Attorney for the county. Ms. Holderman, you're charged with domestic assault. Domestic violence is also the title. It's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. Checking the jail roster, it appears you've been in custody for 14 days. Mr. Robert is indicated to your lawyer that if you pled guilty to this charge, he would have no objection to me releasing you from custody, scheduling this matter for sentencing out more than 10 days. And if you're eligible for the statutory deferral, where you would do a probation, and if you completed the probation, charge could be taken off your record, that he would have no objection to that. I can't do that unless the prosecutor agrees, and they do agree. I'm not 100% sure you're eligible for this. I think you have a previous domestic violence conviction.
She had a case, she was charged with domestic violence in 2013, but it pled to disturbing the peace according to what we have.
All right. Well, we'll look at that. So, Ms. Holderman, would you like to talk privately with your lawyer for a minute and see what you want to do here this morning?
No, I'm okay with doing that, honestly.
All right.
I I normally wouldn't say it like that, but I know that I'm guilty for this. I'm gonna take that full-heartedly, so.
All right.
I also have to say that I've lost my vehicle during this because he chose to have my vehicle impounded. I'm also full-heartedly taking responsibility. Milton, you know me more than a lot of people.
Yes.
I hate to admit, I think my husband was right. I think it's something that I needed. He threw me sideways, told me we wanted a divorce, and it kind of flipped my brain a lot. Dang it, I don't wanna cry. But
All
I
right, well,
needed
let's
this.
talk,
Needed-
let's talk about this.
needed
I mean,
second
actually,
economy. I needed to get on top of what I needed to do for myself, so I needed this to be able to do that.
good morning. Well, you and I have had this conversation in the past. Looks like we have some visitors here this morning. And you've done a probation before. For reasons I don't understand, this isn't in my queue. Give me a moment.
No, I'm good.
This is 1601. All right, the allegation, let me get the actual complaint, is that on or about 8/29/24 that you assaulted Brandon Hicks, your spouse. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. I stated the plea agreement that if you entered a plea to this charge, prosecutor would not object to releasing you on a bond pending a sentence. It would not object to the domestic violence deferral. Was that the plea offer as you understood it, Mr. Gibson?
Yes, Your Honor.
And Ms. Holderman, is that what you understand?
Yes,
All right, you understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury. There will not be a trial. Do you understand that?
yes,
If you had a trial, you would have the right to be represented by an attorney. Mr. Gibson is here. Mr. Gibson has actually gone the extra mile to file this bond motion, but you could hire an own attorney of your own choosing if you wished. If you had a trial, you would have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you. And you have the right to be presumed innocent, unless the state was able to prove your guilt beyond a reasonable doubt. You understand all that?
yes,
All right. Now, you and Brandon Hicks were married, is that correct?
still married.
All right. And at that time, you were living together over near Burr Oak?
Yes,
And you were separated, as I understand it, and according to the affidavit booking form, you drove over to his house because.
I didn't go to the house.
All right, well, you met him, you waited outside the house for him to come out, is that correct?
No, I was not anywhere near the home at all. I was around, like, down the road from the house. I didn't want the kids to be involved because I promised his mom I would not allow that to happen.
All right, anyway, he came out, you stopped his car. Tell me what
Yes.
happened then.
There's a poll in chat. If you can vote, that would be awesome.
kind of pulled away. I don't know all of it. I can't think of all of it, but we pulled away, wound up pulling back over again. Somehow in the midst of everything, I want to punch him. I don't exactly know for sure. I was too angry to, and that's me being honest. That's one of the things I'm working with Pivotal on.
You punch him in the face, right?
Yes.
Oh, that's certainly sufficient. Now, on the complaint, it shows the Henry Street address in Burr Oak. The jail stuff shows the Centerville address, which is, I think, your mom's address, but that's not right. I think your mom's in custody too.
Yes. I'm either
Where are
gonna,
you gonna go?
I put an application in for the Hope House. I'm waiting for a response and tell that I'm gonna go and talk to my son about staying there until I get into the Hope House. If not, I'm gonna ask my brother if I can stay there. My goal ultimately is for the Hope House.
I think that's a good placement. You'd stay there before, hadn't you?
Yes. Ouch. You know, whatever I do notice, and the one thing I'm not doing is going anywhere near my home at all, unless it's with an officer.
Well, it's a condition of your bond that you not go there.
I have a PPO order on top of that, I'm not going, it's not worth my. Since I've been incarcerated, the one thing I'm learning is how much brain plays an amount of mental distress to my brain, so I'm not allowing any contact, whether it's. I know it's bond stipulations, but besides that, even if it wasn't, I'm not, because I can't have it.
All right, so are you connected to Pivotal right now?
Yes. They're waiting for a release for me to set up my psych eval, my appointment with Betsy and my appointment with Alicia. I missed those being here. And then I also have an appointment on the 23rd or the 24th with Cover Bridge for my Vivitrol shot and my something else to them. They're gonna refill my medicine so that I can have them on the right doses.
Oh, well, let me ask you a couple things. I couldn't tell from what I was looking at. Had you been drinking when this happened?
I'm going over to Simpson because that was already like very clearly the majority in the poll. Here's one of the people we're waiting for today, Frank Green. He is, my notes say that he is sick and he doesn't, according to him, he doesn't have long to live. But we're also looking out for Peter Heenan, who had a warrant last week. We didn't get an update on that. And we're looking out for the young guy who is allegedly a PDF file. His lawyer is German or Eastern European, and his name is Mr. Badoon, I think, or something like that.
I told Alan to check. I told Alan to check, but he said, no, she's ready.
Oh, thank you.
Mr. Ganatra, please.
Image cannot senior assistant prosecuting attorney for the people. Honor this time that people move to create any conflict between the Supreme Court and the Office of Public Defender. Prosecutor's office does not believe they conflict exists, but if there is one present, based on all the cases today between my office, the Public Defender's office before some of the court. Thank you.
I guess it's you.
defender's office. Your Honor, we as well do not believe that the conflict exists between this office and the court and the public, or the prosecutor's office, but if one did exist, we would think so.
The court, for its part, also does not believe there's a conflict either under the Michigan court rules or the cases decided they are under to the extent a conflict may exist. Given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Ricky Harris.
Good morning, Your Honor. The people.
Good morning, Your Honor. Regina Garrett. On behalf of Mr. Harris, I'm sorry, there's a.
Yeah.
He's there. He just stepped right out of the room, but he's stepping right back.
So he's not there.
There he is.
Harris, could you state your name, please?
Ricky Harris.
Thank you. Okay, what are we doing?
And Your Honor, today is the date and time set for a book class conference. I had an opportunity to briefly speak with Mr. Harris. I am also, the court should be in receipt of my motion to withdraw in this case and an order appointing Mr. Drugas, if Your Honor is so inclined to do so. Mr. Harris is in agreement with that. I spoke with him. His earliest out date from where he currently is July 31st of 2025. So he has.
Sign the order, Mr. Drugas, go.
I was providing discovery from this case. I do estimate that Teresa County, I do need to meet with her. I did sign a form for an adjournment. Ms. Harris, can you hear me?
Yes.
Okay, I'd like to adjourn today. Do I have your permission?
Yes.
Okay, I did sign that form and certification here. That's perfect for you.
All right. What's today, the 12th? All right, let's go 2 weeks out. Probable cause conference, September 26, 2024, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor. And my motion was granted.
Yes, it was.
Thank you, Your Honor. I appreciate it. Have a
Thank
lovely
you.
day. Bye-bye.
That's one case. Calls the case of the people versus Randall Bond.
Good morning, Your Honor. Marcia Fisher on behalf of Mr. Bond.
Bond, can you state your name, please?
Yes, Randall Bond. Good morning, Your Honor.
Good morning, sir. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
The plea form indicates that the defendant would be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. It's also an agreement of the parties that the defendant would participate in the Jackson County Drug Court.
That's an accurate reflection, Your Honor.
Right, Joe.
All right, very good. Mr. Bond, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, state your name again for the record.
Randall Bond.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
And understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes, I do.
Are you on probation or parole?
Chippewa County, yes.
Sorry?
Yes, in Chippewa County.
All right. So at the time of this offense, were you on probation?
Yes.
All right, I have to advise you that this could be considered a violation of that probation. If it is considered a violation, that court could sentence you to the maximum allowable under those other charges. You understand that?
Yes.
Understanding that, do you still wish to plead guilty to these charges?
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty?
Yes.
January 2nd, 2023, at the location of 5495 West Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes.
Had you used it?
Yes.
And did you know what you were using was methamphetamine?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant? Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1481. Probation sentencing will be
25th at 1 p.m.
September 25th, 2024, 1 p.m. That is before me. Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Bond.
Thank you, Your Honor.
Court calls the case People versus Jennifer Hiller.
Senator Jay Bond on behalf of Ms. Hiller, here's the assistant from the Wexford County Jail. Ms. Hiller, can you please state your name for the record?
Jennifer Hiller.
Thank you.
I have before me a plea form. Is this what we're doing today?
Yes, that's still what you plan on doing today, Ms. Hiller?
Yeah.
Okay, thank
The
you.
plea form indicates that the defendant will be pleading guilty to the charge of use of methamphetamine. Upon her successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct. Is that your understanding, Ms. Hiller?
Yes.
Thank you.
Raise your right hand, please. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record, please.
Jennifer Michelle Hiller.
All right. Hiller, this court's understanding that you're going to plead guilty to the charge of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Do you understand that?
Yes, I do.
Understanding all of that, do you still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes, I am.
Were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, they have not.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you are indeed guilty?
Yes.
October 24th, 2023, at the location of the Huron Valley Correctional Facility in Pittsfield Township, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes, I did.
Had you used it?
Yes, I did.
And did you know what you were using was methamphetamine?
Yes.
Counsel, have I complied with the court?
People are satisfied. Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be
September 25th at 1 p.m.
September 25th, 2024, 1 p.m. That is before me. Bond in this matter will continue. Thank you, ma'am.
Thank you.
Court does call the case People versus Jessica, is it Komanek?
Yes.
Image Canatra for people.
Assistant Public Defender Hannah Apple hearing on behalf of Ms. Komanek. Ms. Komanek, please state your name for the record.
Jessica Nicole Kamenik.
Yeah, I'm asking for an adjournment so that I can speak with Ms. Komanek at Monroe County Jail.
You need 2 or 3 weeks,
Your Honor, 2 weeks, please.
3 weeks. Would be October 3rd. 2024, 9 a.m. bond continue. Yes, sir. Court does call the cases of the people versus Kelton Martin, 2 cases.
Image Canatra for people. Defender on behalf of Mr. Martin.
Got him.
Sorry, I'm muted. I just wanted to pause a minute because I'm about to go into another little focus session. So I wanted to quickly show you guys some of the courts that I watch when I'm not live streaming. Why did I click off this now? Give me 1 sec. Just had it open. I love Brayley and then 57th Magistrate Brayley. 57th Daniel is his first name. For some reason, his surname has absolutely escaped me. Their sass, the 2 of them with the sass, is amazing. This is David Goggins. No, not the Navy SEAL motivational speaker. This is just one of the most random but sweet courts. Of course, he's not going to show his face now because I wanted you guys to see. This looks like it's about to be a trial. Can you speak, please, Judge? Oh, okay, he's not speaking. In the meantime, I'm going to quickly check. There's another one that I watch. Oh, why is
So you can see him, but he's here in my office with me. Okay.
Kansas on so early in the day?
1 moment. Thank you.
You know how to get in there? You know how to get into the breakout room and stuff?
It's 9 a.m., but it seems earlier than usual. I just found a bond hearing. I don't know if they're going to take it down straight away, but it's an hour in, so we're not going to catch up. It's DeKalb Superior Court, DeKalb County. Is that how you say it? They've taken all their other hearings down, so I'm not confident we'll get to see the whole thing. So I'm not going to start that. I like Judge
morning,
Crum.
everyone.
Morning, Judge.
Morning, Your Honor. Morning, Kurt. All right, Chris, do you want to take up the Cheever case first?
That'd be fine, Your Honor, once we've got Ms. Gillette here.
Okay, she's not here.
Oh, that's Mr. Cheever, not Ms. Gillette, though. Never mind.
And Kurt, you're here on Alan Furman. I am, Your Honor, and he's sitting right across from me. I can bring him around so you can see him, but he's here in my office with me. Okay.
Morning, Your Honor.
All right. Good morning. You can have a seat now. Just had to prove you were here.
I also like Manning, but I find that there's a lot of like watching. A lot of it's like skipping through, so I tend not to watch Judge Manning live.
Whatever makes it easier. So if you want forward.
Also Thurston, but only sometimes. Sometimes Thurston County's courts are the most boring things.
Right. Are you Jaden Lever? Did you just come in?
Yes, sir.
Okay. We're still waiting on the prosecutor.
Okay, I'm going to skip ahead so that we don't miss the end of it to where the prosecutor joins. Okay, we're live.
We're trying to track down Miss Gillette, so appreciate everybody's patience.
Oh, I saw such a wild theory. Let's see if I have enough time to say. There is a channel. Okay, I'm going to keep an eye for when the judge pops up. There is a channel on YouTube that believes that Gillette, the prosecutor, is actually Old Squishy Gardener. You know, the channel that shows court cases. And that's why Old Squishy Gardener sometimes has videos that aren't still up on YouTube or whatever. They've got this person has an entire channel of this conspiracy theory about Gillette and how Webster and Gillette are like working together. Dad, I'm in court. Connor, I try to be on every day. However, this is, I still have a day job, so it's 4 p.m. here. What I sometimes do is I put on the stream and I work while I listen. And then I'm like lurking in the comments, or I'll pop on and chat a bit when I'm in between two things and need a little bit of like a few minutes break. But I try to stream most days from about, I think it's like 8 a.m. I don't know if you're in the US, but it's about 8 a.m. in the US until like, Steve, what time is my 10 p.m.? So it's 4 p.m. here, it's 10 a.m. No, it's 9 a.m. Central. So 6 hours from now.
Angela, can I get a breakout with Trevor Dolezal?
Yes, one moment.
Thanks.
I'm so scared to hop off this channel because if we fall behind, we won't see the end unless I just keep it on in my ears. And
It's just right.
Well, now all we're short is Chris Pate, and the whole gang would be here.
Well, he doesn't have anything on the docket today, Chris.
Oh, and William. I forget about him. Poor William.
Yeah, no, he's not here either.
Yep.
So you're just stuck with me.
that's it.
I have a friend that is a transactional attorney somewhere else in the country, and he watches these dockets. And he's like, "How much do you know about these guys?" And I said, "Well, we all live in separate places, generally a pretty far range in the state, but we're the only attorneys that take appointed cases here." So
Yeah. Well, at least you didn't say anything bad about me.
Well, you don't know that.
I have people ask about the hand in your office, the lamp often.
Oh, that's a Wichita State #1.
Oh,
that's what it is.
Angela, I got booted from the meeting. Can we try that again?
Yes, one moment.
Yeah, I'm often
Okay.
I'm often working and
All right, let's take up the Joe Cheever case first. This is in the District Court of Greenwood County, Kansas. Cases entitled State of Kansas versus Joe D. Cheever, case number 24 CR 15. Would counsel announce appearances, please?
May it please the court, the state appears by Joe Gillette, County Attorney.
The defendant, Mr. Cheever, appears in person with counsel Christopher Ambrose of Harvest Legal.
All right, we are set today for arraignment. Mr. Ambrose, does your client need a formal reading of the charges?
No, Your Honor, he's aware of what he's charged with. We'd waive formal reading, enter a not guilty plea as to both counts on the complaint, and ask that we get this set for further proceedings.
All right, are you ready to set this case for jury trial?
That's probably fine, Judge, because I know trial dates are generally quite a ways out over here, so.
My next trial date is December 10th at 9 o'clock. Pre-trial, December 5th.
That'll work, Your Honor.
All right, the December 5th pre-trial at 9 will be a Zoom docket.
Okay.
The jury trial, obviously, starting December the 10th, will be an in-person appearance, Mr. Cheever.
Okay.
And if, Mr. Ambrose, you all get something worked out on this case and want to get it on either the October or November regular dockets, just let us know.
Yes, Your Honor. We can do that.
All right, any other matters to take care of on the Cheever case today?
No, Your Honor.
All right, we'll be in recess on the Cheever case. Mr. Cheever, you're excused.
We'll get a follow-up out to you, sir.
All right, Chris, are you ready to go on this Bradley Smith sentencing?
Yes, Your Honor.
All right, Mr. Smith, can you hear me okay?
Yeah, Judge, I can hear you fine.
All right, we'll go on the record in State of Kansas versus Bradley Smith, case number 23 CR 214. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette County attorney.
May it please the court, the defendant, Mr. Smith, appears in person via Zoom with counsel Christopher Ambrose of Harvest Legal. We're from separate locations today.
All right, thank you, counsel. We were last before the court July 3rd. At that time, Mr. Smith entered a no contest plea to one count of unlawful possession of a controlled substance, a level 5 drug felony. Sentencing was set over for today. I am in receipt of a pre-sentence investigation report indicating a criminal history score of C. Ms. Gillette, any objection to the criminal history score?
No, Your Honor.
And Mr. Ambrose, any objection to the criminal history score?
No, Your Honor.
All right, Mr. Smith, did you have an opportunity to go over the criminal history with your attorney?
Not really, no. I mean, I know my criminal history, but
Okay, are you objecting to the criminal history score of C?
I don't know what that means, Judge.
Judge, if you could give me a minute, I'll make sure we're clear on that. If that's all right.
Okay, we'll set up a breakout room, Mr. Smith, so you can visit with Mr. Ambrose privately.
I don't know what this is about. I don't think it's meant for me. I'm glad you found me. This is slow moving this morning. Normally this court is like quick, quick.
Out of the 23 pages that we dismissed because Desiree was nowhere to be found. sure that we have a copy of everything, the old case and the new case.
Mr. Lever, do you know how to mute that camera until your case is called?
You unmute the camera. So muted.
Thank you. Kurt, are you just going to be setting new dates on your cases?
Yes, Your Honor.
Okay, let's take those up. All right, we'll go on the record in two cases, both entitled State of Kansas versus Alan Furman, 24 CR 124 and 24 FG 12. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
May it please the court, Alan Furman appears in person and through counsel Kirk Kearns.
All right, the felony case that's set, looks like for preliminary hearing control. Usually those are handled by Judge Webster, but I guess it's been assigned to me at this point. Mr. Kearns, what does your client need a preliminary hearing?
Your Honor, I talked with Jill. He's got a corollary case out of Butler County that would impact, hopefully, the resolution here. I'm trying to work on a global resolution. If I could have a final control setting with the court and Jill's consent, I'm hoping we'll have a resolution offer over in Butler County. And if we don't, then I'll just set it for prelim here. But I'm trying to work. I think the Butler County case in everybody's mind's a little more serious, frankly. So we're trying to get that resolved.
Okay, so you just want to set this.
Good morning. Can you hear me?
Morning, Your Honor.
Thank you. There we go. Okay. 14B District Court is now in session. This is Magistrate Hillary Braley presiding. Now calling case numbers 24W001972A, B, and C. Can I have names for the record, please, starting with the deputy?
Deputy Alex Phillips, PHILLIPS.
Okay, thank you. And Mr. Hall, can you please unmute and state your name for the record?
Gabriel Hall, Gabriel Lydell Hall.
Okay, thank you. So today is the date and time set for an informal hearing in these matters. What I have is a citation dated June 29th, 2024, that charges that on or about that date you did operate a motor vehicle on Ecorse Road at or near Pinewood Avenue, and you were operating while holding or using a mobile electronic device. That is a civil infraction. There is no criminal penalty associated with that, no jail time, no probation. There is, however, a $240 fine associated with that. Now, as part of the same citation, so the same date, time, and location, you are also cited for no proof of insurance. That is, again, a civil infraction. And lastly, you were cited for no proof of registration. And again, that is another civil infraction. So that is why you have A, B, and C tickets. Okay? Now, before we get started, Deputy Phillips, was there anything that you wanted to say?
No, Your Honor, just about the case.
Okay, so Mr. Hall, you have three basic options when it comes to each one of these tickets. Okay, so for each ticket, you can accept responsibility. That is basically admit to the various civil infractions that you were charged with. Basically, you'd pay the tickets. You can accept responsibility with explanation so that the court can take into consideration any mitigating factors and potentially lessen or eliminate the fines. Finally, you can deny responsibility. That is, deny that you were operating while handling an electronic device, deny that you did not provide proof of insurance or registration, at which point we would proceed to the informal hearing. The court will swear in both sides, take testimony, and make a decision based on preponderance of the evidence, which is a 49% to 51% standard. Okay? So, do you understand those options?
I do.
Okay, thank you. So, in regards to the operating while holding or using a mobile electronic device, which of those three options would you like to go with?
Can I tell you what happened? Yeah.
Well, so, okay. If you are going to deny responsibility for what happened, then we're going to swear in everybody and take testimony from both sides. Okay. If your purpose is to give me an explanation so that you can tell me what happened and I could potentially lessen the fine, then I'm still going to swear you in. But you'd be basically admitting to the civil infraction.
Yeah.
Okay.
I'm just gonna go ahead and pay everything because I set up a payment plan and just be done with it. But I do have proof of my registration and I did have insurance. I just couldn't find it.
Okay. So, okay, so you're saying that you do have proof of insurance and your vehicle is registered. Deputy Phillips, is there any way for you to confirm that?
When he ran my license plate, it said. When you ran my license plate, it said it.
Traffic here on Janesville. Your Honor, he has out-of-state plates where we're unable to determine insurance.
Okay, were you able to determine registration?
We were.
Okay.
Hello, Your Honor. I think your deputies like my car around here. It's real pretty, I guess. I don't know what's going on. I got pulled over 3 times for nothing. Like absolutely nothing. I don't know what's going on in the city of Ypsilanti.
So,
don't have felonies, don't have warrants. So I don't understand. I ain't never been in no major trouble. Only thing, you can look at my record, driving on suspended license. I'm 50 years old. I'm not out here fooling around doing dumb stuff. So I don't understand why this car right here is getting pulled over so much. I don't understand it. I really don't understand it.
I can appreciate that. I can appreciate that you are frustrated. What I am going to do really quickly though is swear you in. Can you raise your right hand for me? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth to the best of your information, knowledge, and belief?
Yes, ma'am.
Okay, thank you. So just so that I'm confirming this, when it comes to the operating a mobile device, are you accepting responsibility with explanation?
I am.
Okay. And in regards to the no proof of insurance citation, which option are you choosing for that?
Can I just bring a copy of my insurance down there? Or no? Or how can I do that?
So, and I did receive the other paperwork that you dropped off. Which, did you need this paperwork back?
Yes, ma'am. No, ma'am. No, ma'am. I can get other stuff. No, ma'am.
Okay. So, if you wanted to come by and drop off proof of insurance, that would be fine with the court. You can do the
Okay.
same with the proof of registration. But as far as the operating a mobile device, did you want to give the court an explanation, or what are we doing?
Yes, I must get a quarter information. I'm going down Equals Road. The phone drops. I pick the phone up. As soon as I get up, he's behind me. So I throws my hand up like this with my phone in my hand. I thought because I've been pulled over numerous times. I'm like, what you pulling me over now for? So I threw my hands up. My phone was in my hand. I wasn't on the phone. I grabbed the phone. That's what I'm thinking. He finna pull me over for not having the seatbelt on because I took my seatbelt off to get the phone off the floor. So I'm thinking I'm getting pulled over for not a phone in my hand. That's what I'm thinking I'm getting pulled over for not having the seatbelt. But I did have my phone in my hand. But for the reason my phone was in my hand, I'm throwing up my hands like, why you pulling me over now for? Because I'd already been pulled over 2 times. This is the 3rd time. So I'm like, what you pulling me over now for? That's why my phone was in my hand at the time. But like I said, I did my hand.
Okay. Thank you. So
It gets frustrating, Your Honor, when you ain't doing nothing and you get pulled over numerous times. It gets frustrating. And like I said, I'm from Alabama, and I know when a person is bothering me. I know this.
So what the
Back
court
to take care of everything. I'm back in Michigan to take care of everything.
Okay.
It's the only
So-
reason I'm here.
Okay, I appreciate this. What the court is going to do at this time regarding the operating an electronic device, the court is going to, so like I said, that's ordinarily a $240 ticket. The court is going to sentence you to pay $140.
Yes, ma'am.
So I'm knocking $100 off. You still shouldn't be taking your seatbelt off and bending over to pick up your cell phone. Like, if you're going to do that, just pull over, please.
Over.
Okay. So yes. So
Understand that. We'll take that in great consideration.
thank you. I appreciate that. Now, regarding the no proof of insurance and the no proof of registration, what I am going to do, if you are you able to get here today?
I'm working right now, so probably I don't get off to 5.
Okay. What about tomorrow?
Yes, ma'am. I should be able to do it tomorrow.
So if you can get here by close of business tomorrow, we close at 4:30. And if you have your proof of insurance and your registration, then what I am going to do with the registration ticket is waive the fines and costs on that. For the no proof of insurance ticket, it'll be $25. Okay. If you don't get here before we close tomorrow, then it'll be the regular amount for both of those tickets. Okay, which the no proof of insurance is $155, the registration is $120. Okay.
Okay, I'll be there.
Okay. Okay, thank you. So then this hearing is concluded, and Deputy Phillips, I think that was your only one with us, correct?
Yes, Your Honor.
Okay, so both of you are free to sign off of Zoom.
All right, have a blessed day and thank you.
Okay, thank you.
Have a good day.
Thank you.
Good morning. Can everybody hear me?
Yes, good morning, Your Honor.
All right, thank you. Good morning, Ms. Jeske. If I go too fast or somebody goes too fast or you cannot hear something, please let me know, okay?
I will, thank you.
We will go on the record in the matters 24 CT 32, 24 CT 68, State of Wisconsin versus Philip Ambeling. The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Ambeling appears in person without counsel. We're set here today in these matters for an initial appearance as well as a status conference. In 24 CT 68, Mr. Ambeling, you have been cited with an additional charge of operating while revoked. Did you receive that criminal complaint?
I did.
And you can read, write, and you understand the English language?
Yes, ma'am.
And did you read that criminal complaint?
I did.
And that charge that you are charged with in that complaint, it's the same charge as the other matter. And so you recognize that and understand that?
I do, Your Honor.
Do you need me to read either the charge or the maximum penalties to you or anything in that complaint at all?
No, but I would like to have the opportunity to tell you why I was driving that night.
We're going to get right there.
Okay, thank you.
And are you still on Main Street?
Yes, ma'am.
Telephone ends in 4335.
Yes, ma'am.
May we send you text message notifications of upcoming hearing dates?
Yes, you may.
All right, not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Mr. Ambeling, I'm going to give you a little bit of caution here with regards to the things that you say here today. Right now, these are simply an allegation, and everything that you say here today can or could be used against you in a case or in prosecution. So if you say something about, let's just give an example, I was driving, but it was an emergency, or I was driving and whatever, it's can be held against you, okay?
I understand.
All right. So with regards to these matters, quite honestly, where I am in these cases is just where are you in getting your license?
Okay, last time I met with you, Your Honor, you gave me till the 12th of September to secure my license. I was eligible to do that on the 29th of August. I went into the Department of Motor Vehicles and I did get my license reinstated. And I stopped by the district attorney's office last week and I dropped all the information off because you asked me to do that. So other than that, I've making all my payments on the fine on a regular basis and doing everything I've been asked to do.
All right. So you do have a valid driver's license?
I do.
So Mr. Schmidt, has your office received that?
You reinstated on July 30th? Does that sound right?
It's 29th, yes, 30th. I was by your office and you weren't there and I gave it to your office staff. Proof that I paid the state with the money they needed and that they reinstated my license.
You know when you went in?
Pardon me?
Do you know when you went
I
in?
believe it was on Friday. There was a young man in there and a couple gals and I explained to them why I was there and they said, well, give us the copies of what you have. They copied them, gave me the originals back and said, okay, we'll give them to you.
Let me ask you this, it'll be easier. Do you have it with you?
My license, yes.
Yeah, I see it.
I did look it up with Wisconsin DOT and it is currently valid.
It's currently valid.
Doing it this way because Laura's been gone for a while, so she's gonna process. Oh. All right, I moved to dismiss both the OARs.
Excellent. Good job, Mr. Ambeling. You've done everything that you needed to do. And this was just a backlog of from a charging decision to actually being charged with this new case. Both matters will be dismissed, okay?
Thank you, Your Honor.
Good job, and I'm glad.
I am too.
You did a lot of work in between.
I did.
So I'm proud of you. Thank you.
Okay.
All right, good luck. You're free to go.
Okay.
Mr. Gramstrup and Mr. Peterson.
Thank you, sir.
We will go on the record in the matters 24 CF 56, 24 CF 166, 24 TR 264, State of Wisconsin, County of Burnett versus Roland Peterson. The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Peterson appears by video conferencing in custody in Burnett County Jail. We have Christopher Gramstrup by video. We're set here today in this matter for an initial appearance in 24 CF 166 and status conferences in the other matters. Mr. Gramstrup, were you able to go over the criminal complaint with Mr. Peterson?
I have not gone over the criminal complaint with him, Your Honor. I checked on CCAP the other day and again this morning. It doesn't look like I've been appointed to that case yet. But I did discuss with him the charge, so he is aware of the charge and the potential maximum penalties. I think we can proceed with the initial appearance on it. But I would need, I'm trying to remember, I think I'm court appointed on 24 CF 56. I am.
I believe you are. So I am
I
going
am.
to appoint you to this new matter as well. Mr. Peterson, did you go over, do you understand the allegation of the felony bail jump, which alleges on or around July 15th, 2024 in Burnett County, Wisconsin, having been charged with a felony in Burnett County case number 24 CF56 and having been released from custody, you intentionally failed to comply with the terms of your bond by having contact with a co-defendant. Maximum possible penalty could be a $10,000 fine, 6 years of incarceration, or both. Do you understand that charge and that maximum penalty?
Yeah, I understand.
And you waive formal reading, Mr. Gramstrup?
Yes, Your Honor.
All right, he's entitled to a preliminary hearing. Is he requesting it within time limits?
We would waive the time limits.
Mr. Schmidt, is this your case or Mr. Renicky?
It's mine.
I can do October 4th at 10.
That works just fine.
All right, October 4th at 10 o'clock, we will have a preliminary hearing. Mr. Gramstrup, if this is a waiver, obviously you can appear by video conferencing. If it is not a waiver, you can appear by video if Mr. Peterson is okay with that as well, and he may also appear by video.
Very good.
Thank you. We are adjourned.
Have a good day.
You too. Morgan Bridges. Gavin Benjamin. We are a little early. All right. Well, good morning, Ms. Jeske. If you have any questions, or again, if you can't hear something, sometimes Mr. Schmidt is notorious for kind of mumbling or speaking softly. So sometimes I catch it to tell him to get the microphone, but sometimes you may have to step in and do so as well.
Okay, thank you.
But he has a lot of good, important things to say, so we need to make sure it's all on the record.
Hello there, stranger.
Okay, I don't have anyone else. Okay, I have somebody coming in from a healing center.
My clock still says 9:13.
Well, I'm just trying to make sure we're on time. Okay, we're connecting. Oh, I have to call Dodge. I forgot. So just give me 1 second. All right, who is this at the Healing Center?
Greg Johnson.
All right,
Hello, Your
thank
Honor.
you so much. Good morning. Just give me 1 second, please. Mr. Johnson, you're looking well today.
Thank you. I feel fantastic.
I am so glad you really look the best that I've seen you in a very long time. Huh, I can't call Dodge. Just give me 1 second. It's not working. 165. Point. States. Oops. Danielle, I may need, you're not Danielle, never mind. Oh, it's not working. Just wait 1 second. I'm gonna try something else. I don't know if they're down or it shouldn't be our system. Nope. Nope. Okay. Let me try one more time. Can you tell Mary that the Dodge number is not working to call them, please? And I've tried it 4 times. Oh, wait. It has another little something that went over to the other thing, so maybe that has to be added. Just wait 1 second. Ah, that worked. Never mind. It had another thing that fell over to the next line. All right. We will go on the record in the matter 24 CM57, State of Wisconsin versus Greg Johnson. The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Johnson appears in person, by video conferencing with approval of the court. His attorney, Charles Wingrove, appears in person. We're set here today in this matter for status conferences. Mr. Wingrove, can you please update the court?
Ask the record reflect a special appearance in order to retain all jurisdictional objections, if any. I've had very little contact with Mr. Johnson. I know that he was in counseling. He's now in a wellness healing center. And I just asked the court.
Versus Greg Johnson. The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Johnson appears in person, by video conferencing with approval of the court. His attorney, Charles Wingrove, appears in person. We're set here today in this matter for status conferences. Mr. Wingrove, can you please update the court?
Ask the record reflect a special appearance in order to retain all jurisdictional objections, if any. I've had very little contact with Mr. Johnson. I know that he was in counseling. He's now in a wellness healing center. And I just asked the court to set the matter for further proceedings.
All right. Mr. Johnson, how long are you expecting to be at the healing center?
Normal stay, it'll be another 30 days now.
All right. What's your plan after you leave the healing center?
I'm still gonna be in counseling and therapy at the tribal center in Hurdle. And that's an extensive
The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Carlson appears by video conferencing in custody in Dodge Correctional Facility. We have his counsel, Charles Wingrove, in person. We're set today for status conferences. Mr. Wingrove, please update the court.
Mr. Carlson has been in custody. There's been limited opportunities to communicate with him. Now that he's in DCI, I think we should probably be able to get the matter resolved, hopefully at the next court hearing. I just ask the court to set the matter over again, please.
All right, one more opportunity. Well, since he is already in custody on other matters, I can schedule you for that November 21st at 9:30 status block date.
Thank you.
Thank you. We will see you then. Woody Erickson. We will go on the record in the matter 24 CM99, State of Wisconsin versus Cody Erickson. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Charles Wingrove, Defense Counsel, in person. We have Mr. Erickson in person as well. We're set today in these matters for this matter for a status conference. Mr. Wingrove, please update the court.
As the record reflect a special appearance in order to retain all jurisdictional objections, if any. Despite reasonable and diligent efforts, I have not been able to discuss the matter with Mr. Erickson, that we do have an offer that he would enter a plea to an ordinance violation for drug paraphernalia. To resolve this matter, I should think we could do that today.
Mr. Erickson, do you accept the offer by the state to amend to like a ticket, an ordinance violation?
Yes.
All right. Formal motion to amend count 1.
So made.
Granted. Mr. Erickson, do you wish to enter a guilty plea or a no contest plea?
No contest.
Court will accept a no contest plea. What I'm going to do is I will assess $114.50. That can be added to the additional amounts if you owe some for Burnett County to your payment plan. If you do not have a payment plan, I will order that at minimum $25 a month for this case be paid until it's paid off in full. Failure to pay means the court will enter a civil judgment against you, or you could sit up to 6 months in jail and have a warrant if you don't pay. All right.
Okay.
So go take care of that, and you should be good to go. Count 2 is dismissed and read in.
I'm sorry, Judge, what was the forfeiture again, please?
$114.50.
Thank you.
I
Sorry.
waived the other costs and fees.
So,
Ms. Samantha Evans.
if you want to wait outside, we can discuss it after court.
Who is the inmate that just came in? I thought I
Kevin Hoyland.
recognized. Who are you, sir?
Evan Hoyland.
All right. I cannot name you. All right, we will go on the record in the matter 24 CF 135 24 TR 569, State of Wisconsin versus Samantha Evans. The state appears through Assistant District Attorney Kevin Schmidt in person. Ms. Evans appears in person with counsel Charles Wingrove. We're set today in this matter for status conferences. Mr. Wingrove, please update the court.
As the record reflect a special appearance in order to retain all jurisdictional objections, if any. Ms. Evans lives in Pine County, Minnesota. We've been working with a client service specialist to try to get her IDIP-like programming in Pine County. Most of it is post-conviction, so we're having to get kind of creative, but we're still trying to get that accomplished. She's got limited resources. Right now, we're seeing if we can get the Minnesota equivalent of Badger Care to pay for treatment for her, and we just need more time. I'm sorry.
Okay. All right. I'll give you a little bit more time, but I'm gonna want to have something a little sooner than your November date, simply because I want to make sure that we're on top of this and it's not gonna be, the ball's not gonna be dropped. Can you do a status on October 9th
Can you do that?
at 2:45?
Yes.
All right. I'm okay, since it's a status, if you appear by video or telephone at that time. I just need to be updated on if you've located the services, what you're doing, or if we're going to move this more in a trial posture, because we have to keep it moving. I can't wait forever to see if you find all of those programs and those things, okay? But I can give you time. And so I'm just gonna get an update on the 9th, okay?
Okay.
So if you want to appear by telephone or by Zoom, again, I'm okay with that.
Okay, thank you.
All right, thank you. We are adjourned.
Thank you.
Samantha?
Christopher Merrill?
Mr. Merrill contacted me about 9 o'clock this morning via telephone. He told me he's been diagnosed with COVID and he's been told to quarantine.
All right, well, I will issue a warrant until I get proof. We'll go on the record in the matter 24 CM 108, State of Wisconsin versus Christopher Merrill. State appears through Assistant District Attorney Kevin Schmidt in person. We have Charles Wingrove, Defense Counsel, in person. Mr. Merrill contacted Mr. Wingrove this morning and advised that he had COVID and needed to quarantine. The court is going to issue a warrant, $250 cash. Only judge may quash or posting of the cash. Mr. Wingrove, the court will vacate that warrant upon proof from a medical professional of COVID and the diagnoses to quarantine.
Sorry, I
There is-
want to
I'm sure the court probably
want to
already
jump
knows.
in at Judge
Pending
Washington
Four Corners
because
motion. And
there's something, a
arguing
woman
basically
crying
the
about
court doesn't
something.
have jurisdiction.
Yep,
Just you're issuing a warrant, I bring it to the court's attention.
I appreciate that. Thank you. We'll take that up if and when Mr. Merrill reinstates the case. Robert?
One sec. This lady.
I don't think I can write all this down. So, yeah.
Your Honor, I think I may have forgotten to give you a
That's
sticker, but
okay.
I
Yeah,
can
you-
bring you one.
All right, thank you. I appreciate it. Yeah. Okay. State of Michigan versus Jarrell Sewell, case number 24 FB 1253. I think it is. That additional charges will be added. No, I don't. It's
Okay,
only
I
set
will-
one. Jury is here that you have to pick.
Understood.
May it please this honorable court. My name is Bradley Friedman. I appear on behalf of Sharonda Griffin.
Thank you. Permission, nope, I don't need to say any of that. Ms. Griffin, please state your name.
Yes, ma'am. Good morning. I'm Sharonda Griffin.
Thank you. All right, we're here for sentencing today on these 1, 2, 3, 4 cases, 3 cases. 4 cases. Wait, let me understand something. I think that's what the problem is. You filed appearances on 3 of these cases. Are
I
you
didn't
on-
I didn't realize there were 4, Your Honor. I only thought there were 3.
Okay,
I will be, I can file an appearance on the 4th. Ms. Griffin has retained me to represent her on all these matters.
all right, thank you. All right. Have you had a chance to go over today's day and time schedule for precedence for the sentencing in this particular case? Have you a chance to go over the report with her?
I have, Your Honor.
Are you prepared to proceed today?
Yes, Judge.
Thank you. Any corrections, additions, or deletions to the report?
No, Your Honor.
Ms. McDuffie? Thank you, Your Honor. It is really, this is heartbreaking. This is, I know our last case was sad. I don't know why I'm getting this worked up about it. It's not even my case. I mean, it's not me. Here's why this is so sad. Miss Griffin, her violation of probation is for a case that was so long ago. I don't remember if that was in the late 90s or something. Miss Griffin came into the criminal justice system, I think, with one of those original opportunities to sort of change her life, to not end up like this, to get, and this is one of the longest PSIs we've ever had. To see how so much has just spiraled, and alcohol seems to be at the root of almost every single one of these cases. Miss Griffin was in tears when she finally entered the plea on one of the cases in our court, which started in our court, which were driving with a high BAC with her, it was a .284, with her 2-year-old son in the car. I can't imagine what was going through her mind then and now. And to just see that she then tried to run away from all her problems, cut multiple tethers off, and just accumulated more and more. And now she's looking at prison time. I don't know what did not happen where Miss Griffin wasn't able to just get a hold of this. And it's not even just this state. What we have here before us today is enough. It hurts my heart to see. I don't want to say somebody's life thrown away. I'm glad that that baby is okay from the incident that she pled on. But his life is going to be changed forever too, with his mom sitting where she is and eventually, potentially, in a different facility. Ms. Griffin, I apologize for not holding myself together today. But I truly hate to see this, but I will tell you, your life is not over, ma'am. As emotional as even I am as a prosecutor, this is not the end of your life. And even though you may have to end up sitting for some time with all of these offenses, misdemeanors and felonies stacked up, you can still take this opportunity to make a new life for yourself. But making that new life for yourself is not about where you are, it's about who you are inside of here. It's about getting control of your substance abuse problem. Please engage in anything and everything that's available to you. Do it for yourself. Do it for your son. Do it for your family. These offenses are what you did. They don't have to be who you are. Please make every effort that you can to save your life and then turn it around for your sake and his. And I apologize to the court. No apologies needed. Mr. Freeman?
Ms. Griffin, yes.
Mr. Freeman, you go first, please.
Thank you, Judge. Your Honor, obviously, the Assistant Prosecutor has said more and knows more about this case than I possibly could. I could only tell the court how I came to be involved in this case. I was contacted by Miss Griffin's husband, who's almost completely disabled because of a severe car accident he was involved in. He's now the sole caregiver for her 4-year-old and 1-year-old child. And he's struggling mightily, physically, to take care of them, getting them to and from school, daycare, their activities, going to his own physical therapy that's necessary on almost a daily basis. This is a very, very difficult situation. And I know this is a very difficult situation for the court. Your Honor, I would just note that this is a probation from 1998. That's the year I graduated high school.
No, that's the felony.
I know, but that's what she was on tether. Oh, right, she has the OWI also.
She has 4 cases. She
Right.
has OWI and cutting off her tether 2 times.
I know. And I think that, and I might be wrong, but the tether was placed based on bond violations for the or probation violations maybe for the 1998 case. I want the court to understand that I do believe that my client, although she's now been sitting in jail since the beginning of June, is in a place now where she can have a more profound understanding of the effect that she's had on her children's lives and on her life. 3 months, albeit it's not 5 years or whatever the recommendation is in circuit court, it's a significant amount of time in jail. I would note that during that period of time, she's been engaged in MRT. She's scheduled to graduate and finish MRT this week. She's also received 3 good time cards. She's doing whatever she can to make use of her time in jail. I spoke to Judge Conlon relative to the circuit court case. I convinced him not to enter a sentencing order or not to sentence her last week when we appeared in front of him, and instead give me the opportunity to plead to you in this court to see if you would possibly consider any situation where you would put her on court supervision. I'm sincerely hoping that you would consider that. I know that there was a recommendation for her to enter into another program in the jail, but I know they also have an intensive inpatient treatment. I don't know if she needs to have private insurance to get into that program, but I would know that I think that my client has, certainly she's an alcoholic, that's clear, and she has severe problems with alcohol, but she also has a diagnosis for bipolar and depression. And I know, Your Honor, this is my first time appearing in front of you, but you undoubtedly know, just by your experience, even just on the bench, that alcohol and mental illness is a major, major issue in the criminal justice system. I'm just saying that I'm hoping that the court will, instead of just telling my client that because of cutting off her tether and ignoring court orders in the past, that she's destined just to go to prison on Judge Conlon's circuit court order. I'm hoping that you don't just give her jail time on this case and let Judge Conlon, or have Judge Conlon with no other choice really than to send her to prison on his case. I'm really, really hoping, and I know Ms. Griffin wants to speak to you on this herself. I don't want to tread too much in what she wants to say, but she's got nothing left but to throw herself at the mercy of the court and to see if the court's willing to give her one more opportunity, because she's had several, to give her any chance at not going to prison, a chance at possibly getting back to her children and helping her husband sometime relatively soon. She's willing to do whatever it takes. And I think she's really honestly at a point, and obviously I'm not going to speak for her. I want Your Honor to ask her to speak in her own words, but I think she's at a point now where she's really conceding to her issues, both the alcoholism and the mental health. And she's really ready to aggressively approach them and appreciate that they're going to be parts of her life, probably for the rest of her life. And these are demons that she has to battle forever. But she hasn't been in a position, at least as far as I know, up until now, that she was able to have any community support for the alcohol and the mental health. I know since she's been in jail, she's been on psych meds. She's been seeing the doctors and nurses, and she's trying to deal with her mental health issues. I'm just asking the court to allow her to be on monitoring with Your Honor. Put her in inpatient treatment. I don't know if it's Naomi's Nest or if there's any other place where you can send her to, but she's asking for one more opportunity to try and deal with her demons and face her demons, with the hope that, again, like I said, she can get back to her family and her children, and they can, she'll be able to be a good mother and a good wife. Because before she deals with her issues and her problems, she's not going to be able to do that. And I would just assert, Your Honor, the last thing I'll say is this: she's not going to get the help she needs in prison. So I'm really hoping that you'll give her this one last opportunity. And I'm not asking you to make her probation light in any sort of way. I'm just asking you to set it up in a way. I don't know if there's a sobriety court or anything, but I'm asking you to give her one more opportunity to show you that she's going to be committed to get herself better. Thank you.
Before I listen to your client, I have a number of concerns based on what you just said. One is, even if I gave her 1 year in jail, it doesn't mean the judge has to send her to prison. Why can't he just do 1 year in jail? I don't understand that concept. Having done this work for almost 30 years before becoming a judge, I don't understand what your argument is. I don't understand how that works.
My argument is that if Your Honor would give her a structured sentence, which requires that she go into inpatient treatment, that she receive significant mental health treatment. If there's a place for inpatient that has a dual diagnosis program, that she go into that you place her on.
I understand what your request is. I'm trying to understand how you're making the argument that if I gave her 1 year, she therefore had to go to prison.
No, I'm not asking you to give her any prison time at any jail time.
I know you're not. But what you're saying to me is if I give her jail time, therefore she automatically goes to prison, and I don't agree with that statement.
Oh, no, that's not what I'm saying. Okay. That's not what I'm saying. I'm saying that at the district court level, I believe you have an opportunity to give her more of a hands-on approach in terms of your sentencing and her being on probation, much more so than I think the circuit court would be willing to do, or frankly, would have docket time to do. I'm asking you to put her in a program, and I apologize. I'm not fully familiar with what sorts of dual diagnosis programs.
No, I understand. I understand that part of your argument.
But that's why I'm just saying, in my conversation with Judge Conlon, I indicated to him that I was hoping that if you structured such a sentencing, that he'd be willing to sort of ride along with it. Not that he would dismiss her case. He would still be holding the prison time over her head, but that he would ride along with whatever sentence Your Honor would come forward with. And obviously, if she screws up for you, she screws up for him too. And she still has to do the full extent of prison time that he has available to him in her.
What are her sentencing guidelines on the prison case, on the felony case?
Your Honor, I don't have that file in front of me. I'm sorry. I don't know what the full extent of her guidelines are. I do know that the recommendation indicated in the pre-sentence report for this case, and I know the probation officer might be able to speak to that better than me, but it was somewhere in the neighborhood of 5 years in prison.
I know that's what they said they were going to be recommending, but I wanted to understand the actual guidelines to see what the court's options truly were based on the guidelines.
I can tell you that the underlying offense was unlawfully driving away an automobile.
The other issue I have, I mean, your argument is that essentially I shouldn't punish her for something that she did in the past. I'm not looking at what she did in 1998. I'm looking at what she did in 2022 and 2023. I mean, at those particular points in times when she made those choices, she already had the issues that you're presenting to me today already ongoing. She already knew that her husband was disabled. She already knew that she had children because she was driving in the car with the children in the car at the time. Now, I say all that with the understanding that I know that substance use is a disorder. It is a disease, and she was suffering from that disease. But I have never seen anyone who has taken every opportunity they've been given and immediately throw it away. She cut off every tether to send a clear signal to every court that she does not care. And so today, because she's been sitting in jail for a while, you want me to say, give her another chance, but I'm not feeling that. So I'm going to hear from her, see what she has to say, and see if she can convince me otherwise, because right now, all I see is someone who has dual diagnosis issues, understood, I see that a lot, but not that just those issues. They were not given one, but two opportunities to show the court that they could, in fact, comply with bond conditions or do something to try to help themselves. And they basically said, I'm going to punch you in the face with that opportunity that you gave me and cut off your tether. And some of them, we don't even know where they are. What do you have to say, Ms. Griffin?
Ma'am, Your Honor, first, I just want to apologize to you, the court, Ms. McDuffie, to everyone involved in this case. I understand completely what you're saying. I don't want the court to think I don't have no respect or, I mean, I know the way it looks. I know the way it looks. I really want help, Your Honor. I really want help. I really want help. I've been getting help with my mental illness that I've been suffering with since childhood. I've been getting help with that. I've been I get with clean and school.
I didn't catch the last part of what you just said, ma'am.
No, ma'am. I was just saying that I'm sorry. I've been getting help as far as my mental health. I've been seeing the counselors and I've been in my MRT classes and everything, and I've been seeing the psychiatrist, and they've been regulating my meds as far as my mental health has been going. As far as my addiction, I do want help. Like, it's hard. It's hard. Definitely to try to do it by myself. It's hard. And I do want the help, and I see all of that now. I see all of that, and I feel like, I was messed up then. I was messed up then. I was going through a lot. I'm not making excuses, but I lost my mom, my dad, and it was just like I was taking care of my kids, my adult children, and then I had my little babies. And then my husband got in his accident in 2023, and that's what disabled him. And being in jail, I've had to sit and even dealing with the classes. Well, with the classes, I've done a lot of work looking back and evaluating my life and seeing that, I need help. I need help. I do, and I don't want to go to prison. I don't want to be away from my babies. I would have to, I need to be there for them and my husband as well, but I know I need to get myself together as well. I just need another chance. I know how it looks, Your Honor. And I apologize to you and to Judge Conlon and the McDuffie, Ms. McDuffie, I'm sorry, the prosecutor, the probation department, and everybody. I didn't really, I just need help. I just need help. I want to be here for my babies. I've been away from them now, and I'm not making no excuse because I probably, it's not a probably. I know I deserve it to, be where I am right now. But I feel like I'm working on it, and I want to work on it. I want to get better, to give my little babies a second chance to be a better mom to them than I was, even to my adult children. I want to be a better person for myself. And I want to prove to you and to the other judge, to Mr. Conlon, your Judge Conlon, to Ms. McDuffie, to the probation department, to my kids, even to Mr. Friedman, that I can do this. I can do this. And I'm ready to change. I didn't have any hope at first. I'm sorry, I don't want to take too much of the court's time. But I do really, genuinely, from my heart, apologize, and I beg for mercy from the court.
And when you were given the tethers, can you tell me what was going through your mind when you decided you're gonna cut those off?
Well, ma'am, one of the times I was pregnant and my ankle swelled. At one time I was just completely out of my mind, and I don't know if it was my because I wasn't on my psych meds, and then it was a lot of alcohol and stuff involved, and so but another time it was due to medical reasons, because I do have a seizure disorder and I was in cardiac arrest, and I have heart problems, and then I have swelling. I had a lot of fluid on my body, and yes, ma'am. But the other time, I can't make any excuse for it. I can't. It was just my addiction and my mental health. It definitely was. Yes, ma'am. And I knew the consequences. I know now. I would never, it's so, as clear-minded and stuff as I am now. And I've been doing a lot of, like even reconnecting with my spirituality and everything like that, and just looking, evaluating my life. And so I would never have done that. I don't. I knew it was definitely like Mr. Friedman made it to the point with it was like demons. It was like a dark cloud, a dark period in my life. And it's been there for so long, and I just really need help. I really want the help. And I'm really, like, I'm taking as many steps, and I will do whatever I have to do. But I want to prove it to, everyone, to you guys and my children as well. I want to get my little babies at home, a second chance to get to know mom, to know who I am without alcohol, without it's something hanging over my head. I don't want to put them through this. It hurt my heart when I got in trouble with my 2-year-old son. He's 4 now. He's 4 now. And then I have a 1-year-old. They're whole 2, and I don't ever want them to. I was just really messed up. I was. And I really want to prove it to them and to you guys as well as to myself. I don't want to go to prison, ma'am. I want another chance. I want to prove it to everybody that I can do it.
Mm-hmm. All right, thank you. Anything else from you, Ms. McDuffie, before I impose sentence?
Your Honor, I'm not aware of any sort of potential preliminary COPS conversations that might have happened with Judge Conlon in circuit court regarding her prison time. All I see is that that's what the agent was looking at. So I can't really speak to that. I don't take any position on Miss Griffin keeps saying she needs help. We know, we believe her. We clearly she needs help. I think the trouble that we're looking at here is that it wasn't just that she said she's not making excuses, and ultimately it was her addiction, mental health problems. But regardless of the circumstances of what led up to her cutting off both of those tethers both times, when she was already in violation status, she didn't contact community corrections to report those issues. She absconded, right? So it wasn't that, hey, I need help with this. It doesn't fit well. It's causing me pain. Can you adjust it? It was cutting them off and being out MIA and disconnecting from the court to try to run away from these cases and these issues. And I don't know how we can send her. Of course she needs treatment. Of course she needs long-term treatment. But how can we send her somewhere with a tether to make sure she stays there when she doesn't yet have the skill set to not do that again? When all we can do when we trust somebody to be out of custody is to have a tether and basically obey those conditions so that we can track them and so that we know where they are. And if you've proven repeatedly that you will cut it off and you're in such a situation right now where you need so much help, I don't know that Ms. Griffin is going to be able to keep another tether on. And I don't have these other offenses in Mississippi and Tennessee, I think. I don't even know what the timing was for those. I'm truly concerned about her absconding again, and that's in or out of state. So I don't disagree with counsel that she clearly needs treatment, but I feel like we're in a difficult position on trying to figure out how to deliver that in a secure way. That's all.
All right. So, Mr. Friedman, since defense gets last, I'll give you one very brief opportunity to respond.
I'll be very brief, Your Honor, and I would just say, what's the alternative? Just wash your hands of Ms. Griffin. Judge Conlon does the same. She goes to prison for 5 years, comes back out, receives no treatment whatsoever. I don't see that as being the right result in this case. Again, I would just say to the court, I know she's violated. I know she cut off her tether. I don't think either time she was under court supervision on probation. I think both
times she was on court supervision.
I thought that was for bond. No?
No, one time for certain she was on probation.
Okay. I would just say, if there's anything the court knows of, and the court's going to be more knowledgeable than me, where she can be on tether so the court's at least knows where she is and she's not drinking, and she can be in some sort of significant dual diagnosis program. That's really, really what we'd be asking for. I'm not asking you to be lenient whatsoever with her probation. Any false step and she's done. But I'm just asking you to give her that one chance.
So this is where I am with this. She's had plenty of opportunities to do probation. I'm not doing probation for her. I don't see that as a viable option because she's shown us time and time again what she will do with that. She has cut off her scram tether on not one, but 2 separate occasions. And I don't see a way around that. Unfortunately, trust someone when they show you the first time who they are. We didn't do that. We gave her another chance after that. And she did it again. So I've been sitting here as everyone talked to try to figure out, can I come up with something for her that gives her what she needs so that she doesn't do 5 years in prison. And I don't think that it's really going to fall on me anyway. I think that ultimately it's going to be Judge Conlon that's going to decide what he's going to do about her. And I think that the best I can do for her without subjecting this court or any other agency to another significant loss, because those tethers cost so much money, is to allow her to serve her time in jail and release her to a treatment program, which I'll do. And if the probation, and I'm not putting a GPS tether on her because I don't think it's going to matter. If she leaves that, she'll come back and she'll finish serving her time. If that's not significant enough for Judge Conlon to feel she shouldn't go to prison, then that's not significant enough. But that's the best I have for her, so that if she really is truly trying to get her treatment, this will be probably her one and only opportunity to do it if Judge Conlon goes along with it. And if he doesn't, and he sends her to prison, then that's between the two of them. But At this point, I'm not trying to put a tether on her because I don't think it's gonna matter. She's shown us that she'll just cut it off and do what she wants to do anyway. I'm gonna allow her to be released to an inpatient treatment program that provides dual diagnosis. So she's gonna have a couple of hurdles. One is finding a program that does dual diagnosis, and two is seeing if Judge Conlon is willing to go along with that particular program. But I'm not gonna have her on probation because she's shown she has no real desire when she's out to do that. Everyone sitting in jail all of a sudden finds an opportunity for them to be a better person and it's gonna do better. Based on her behavior while she's out, I don't trust it and I'm not going to agree to it. And hopefully she'll do what's right for herself and her family. If she doesn't, then she'll end up in prison for a much longer time than 5 to 10. So it is the sentence of this court that in case number 22S00158, she served 90 days in the Washington County Jail, credit for time served. In case number 22S, and the other thing I'm doing for her is this. I don't have to give her credit for time served because in reality, she's on PR bond on at least 2 of these cases with me. That's the 24 FB 1104 and the 24 FB 1105. So I could technically give her 365 and just make her sit there for the entire time. But I'm not going to do that. I'm going to give her this opportunity, but this is the best I got for her. And if she says she's learned anything, I hope that she acts in that way and that she does what she's supposed to do. 22S00515, 365 days, Washington County Jail, credit for 114 days served. 24 FB 1105, 365 days, credit for 106 served. And 23 FB 1105, 365 days, credit for 102 served. In each of the cases in which she is going to do additional time, she can be released to an inpatient program that provides dual diagnosis.
Excuse me, Your Honor, you said the 365 days, I would have to do those and then go to the dual diagnosis?
No, I didn't, and I'm still saying, so please
Oh,
wait.
I'm sorry.
To be released to an inpatient program that provides a dual diagnosis for both mental health and substance use disorder. If defendant does not successfully complete that, she is to be returned to Washington County Jail and complete that sentence. So ma'am, what you're gonna need to do, and I'm gonna do something that I don't normally do, is I'm gonna schedule a time to see where you are. Because I'm serious. You've been given so many opportunities, and every time you sit in front of one of us, you give us that same story about how you're going to change. That's how you end up being given an opportunity to be on Scram and all of that, and you just don't do a thing. You just go back to doing the same thing you do every single time and show us over and over again that you don't mean it. So I'm going to schedule this for December 12th, 2024 at 10 a.m. Counselor, if she gets out and she's completed a program or she's in a program, you need to get me that documentation before that date.
Okay.
If I haven't heard from you and I haven't heard from her and she's out, I'm going to issue a bench warrant because I'll believe that she hasn't done what she's supposed to do. Because against my better judgment, I'm giving her this opportunity. It's not what you want, but it's the best I got. Okay?
We appreciate that, Your Honor. Thank you.
Thank you so much, Your Honor. Thank you so very much.
You're welcome.
Thank you to Ms. Duffy.
Take care.
Idea. I'm having Shannon check.
State of Michigan versus Ashanae Wilson, case number 22-00437.
Virtually different for the people.
Kerma Dadrish on behalf of Ms. Wilson seeking permission to practice under MCR 8.
I just want to watch this next woman quick. And then I will hop over to Conlon because I think she's one of my swore at the judge people.
0.120 under the supervision of Mr. Davi Libo.
Ashanae Wilson.
Thank you. All right, the only thing it looks like she's completed thus far. Ms. McDuff, anything from you on this? All right, ma'am. Get you here, but at this point, it looks like you're compliant. You are, you're welcome.
Thank you, Your Honor.
State of Michigan versus Anthony Brown, case number 23 FB 1157.
Virtually different for the people.
Anthony Brown, good morning. Good
Good
afternoon.
morning, Mr. Brown. I guess we're not afternoon yet, so.
Yes, ma'am. Sorry.
Good morning, Mr. Brown. All right, Mr. Brown, we went through a lot to get you here, but at this point, it looks like you're compliant. You are testing like you're supposed to, reporting like you're supposed to. So you haven't spoken to your agent though about your health situation. And so she doesn't have an update. I'm not gonna ask you to give that here. But what's so that was on June 11th. This is the last time you were here. And we're now in September.
Okay. Weird. Looks like it just
September.
ended. Oh. Nope. Just ended. And there's not a new one. So let's just go to Conlon.
Today.
Yes.
All right. So sentencing will be October 16th, and we'll see you back here at that time. Okay?
Okay, thank you.
You're all set. All right. Thank you.
Thank you, Your Honor. Take care, Mr. Bernstein.
Calling number 7, People versus Sean Caldwell, 24556 FH.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
And good afternoon again, Your Honor. Rita Young appearing on behalf of Mr. Sean Caldwell, who is still present by Zoom with us.
Okay. Mr. Caldwell, you can still hear us?
Yes.
All right. Ms. Barroso, any luck?
So I was able to get confirmation from an APA in my office that someone could cover for me on the 13th. I was also able to get confirmation from the lay witness.
Thank you, Your Honor.
24556 FH.
And good afternoon again, Your Honor. Rita Young appearing on behalf.
So, I mean,
Where I was supposed to see
Yes, sir, I can hear you.
All right. So we're here today for a violation of probation hearing. I know that there was a prior recommendation to revoke probation 12 to 60 months in MDOC with credit for time served. Mr. Friedman, I don't know if that's something you're willing to proceed on today, or do you want further time to sort of explore other options, or what do you want me to do?
Well, Your Honor, I do have a proposition. She's being sentenced on 3 misdemeanors in district court in front of a judge, Elaine Washington, on September 12th. I did speak to my client about possibly hiring me to represent her in that matter. And I'm hoping, although I don't have any promises I'm not asking for a promise from the court, certainly no promises from MDOC or Mr. Emmons, but I'm hoping that based on the sentencing that's constructed by Judge Washington, potentially we can get a global resolution that doesn't include Miss Griffin just going to prison. So
the short answer is I'm happy to adjourn this. Do you think the 18th would be enough time? She'd be sentenced on the 12th, or do you want to go out another week just to make sure there's?
She's been sitting in jail since the beginning of June. I do understand that she does have 2 young children at home, and quite matter of the fact is that her husband is somebody that's been injured dramatically in a personal injury case, which brought me into this matter to begin with. And he's caring for these 2 very young children. So I'm trying, time is of the essence. I know she's facing prison. I understand that. What I would
12th
say,
is next Thursday. My next docket after that would be the 18th. I'm happy to do it on the 18th.
what I would say is, can we set it for the 18th for now? I do have a trial that's might start on the 16th, but I'm not sure if it will or not. But I can contact Mr. Emmons and your office if that's a problem, and we can move it to the 25th. But yes, if the court will adjourn this to the 18th, that's what I'd ask for.
All right, Mr. Emmons, any objection there?
No, I don't have any objections. And Mr. Friedman and I go way back, and I was happy to take his phone call. And he's kind of informed me a little bit as to what's going on. So there's probably some stuff to kind of work through here to kind of take a look at all of the circumstances here.
Okay. All right. Well, if the 18th works for everybody, I'm fine with that. So we'll adjourn this to the 18th at 1:30 p.m. Okay.
Thank you very much, Your Honor.
Okay.
Okay, thank you, Your Honor.
Sure. You're all set. You're all set.
I'm sorry.
No, you're good. You're all set, Ms. Griffith.
Okay, thank you, Mr. Friedman. Thank you, Your Honor.
Okay, now to Judge Simpson, where we
You're trying, right? Yeah. Got it. Mr. Martin, can you state your name, please?
Something's happened with my
Councilman Martin.
headphones.
Thank you. What are we doing on these?
Just to adjourn this matter, if I get 2 weeks, I expect you to.
Is there a sheet? What's the reason?
We're working on a resolution.
Fill out the sheet so I can sign that order, please. I will, probable cause conference in this matter will be adjourned 2 weeks out, September 26th, 2024, 9 a.m. Bond continued. Thank you, Mr. Martin. Thank you. All those have to sign those. Finally. Court does call the cases of the people versus Kelton Martin, 2 cases. Got him. You're trying, right? Yeah. Got it. Mr. Martin, can you state your name, please? Kelton Martin. Thank you. What are we doing on these?
Just to adjourn this matter, if I get 2 weeks, I expect you to.
Is there a sheet? What's the reason?
We're working on a resolution.
Fill out the sheet so I can sign that order, please. I will, probable cause conference in this matter will be adjourned 2 weeks out, September 26th, 2024, 9 a.m. Bond continued. Thank you, Mr. Martin. Thank you. All those sign those. Thank you. Finally. Court does call the case of People versus Shay Rogers. Pardon? Is he on? Got it. Oh, I got it. This is a PD case.
Mr. Rogers.
Mr. Rogers, can you state your name, please?
Shay David Rogers.
Thank you. What are we doing?
It's my understanding that the last time this matter was up, the prosecutor was looking at whether or not he would proceed on these charges. Is there an answer on that? No, this was Ms. White's case. I'm sure where she is.
There was something represented in court. There's nothing in my file that this case was going to be dismissed. There's some communication just forwarded to me. Happy to consider it. But
Understand. The judge, I'd be asking for a jury.
She's right. Ms. White, this is your case on Rogers. What were we doing on this?
We're gonna ask for the jury, Your Honor. Assistant Public Defender Counsel, Jay Rogers.
Fill out one of the sheets. This matter's adjourned September 26, 2024, 9 a.m. Bond continued. Thank you, Mr. Rogers. Court calls the case of the People versus Victor Barnes, 2 cases.
So we have a kind of get one to the case ending in 11:27, Your Honor.
You're bringing it. He's not up here.
No.
Okay, hang on a second. We gotta get him out. They got it. Victor Barnes. You guys are gonna have to make room on that front row. Vincent didn't move. Vincent's like, that could be me. I'm not moving. Good morning. Your name? All right.
Yeah, we have to make a waiver.
Yeah, are you waiving also? All right. Mr. Barnes, you're waiving your right to have a preliminary examination, is that correct? You understand that a preliminary examination in these matters is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand that by waiving these proceedings, you'll not have those hearings and you'll proceed to circuit court for further resolution. People also waive their right in these matters.
That's your honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts.
Thank you. Your Honor, as to that, now it's receiving information with one remains to be the same.
Defendant having waived formal reading, standing mute to all charges, court will enter not guilty pleas. Pretrial in these matters will be set for
September 24th at 1:30 before Judge Conte.
September 24th, 2024, 1:30.
Thank you.
Thank you.
Bond will continue. Yes, sir. Court does call the case of the People versus Robert Johnson. Where's the rest of this? State your appearances first.
Justin Lancaster, I mean, I think all.
Your Honor, good morning. Mark Ellis, Pacific Robert Johnson.
Your name.
Robert Johnson.
All right, what are we doing? I have half a form not filled out. I don't know if you're requesting an adjournment or what you're doing. Yeah, there's the rest of it.
Form I fill out the front. I have the brand new one. Also, I filled out.
Take the new one. You filled it out?
I shall.
Okay. Oh, you haven't. Okay, go ahead. What are we doing?
Judge, I just got hired yesterday. I do not yet have discovery. We're seeking an adjournment to the PCC.
Any objection from the people?
No, Your
October 3rd, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Make sure you get the form with the reason. Court calls the case People versus Dwight Miller. Why are all those people on that wall? They're gonna have to. They're gonna need them. They can't crowd that area, and it's Constantino that's causing the problem. Just. Good morning, Mr. Burgess. Good morning, Ms. Tanner. Your name, sir? All right, what are we doing?
We are proceeding with the discovery. This matter we are requesting the same day.
So all discovery is complete.
Yes.
Would people have their witnesses available on the 24th?
Yes, Your Honor, and
On the 24th.
it's been mentioned that there's a video supposed to be downloading and that it's like sharing. Obviously, if you can reach out within this 2-week period, I, of course, the directive, and that not complete.
Preliminary examination in person will be set September 24th, 2024 at 9 a.m. before Judge Washington.
Your Honor, I know you hate it, but I do want to need to address the issue.
I don't hate it. I just- If it's a long argument, then yes, I'll hate it for the moment, but I'll hear it, but go ahead.
Your Honor, the bond is currently set down at surety. We do understand the serious nature of the charges in this case, Your Honor. However, my client obviously is in a wheelchair. Normally, they would work with a cane judge, but he does have some medication, specifically Neurontin and gabapentin. He's not receiving in the jail, understanding those are controlled substances, but that's normally what he needs to be able to perform. He's literally on the floor of the jail for the most part, Your Honor. He does have a 16-year-old son, Your Honor. He lives locally. He's not a flight risk. Any criminal history is pretty far in the past, Your Honor. And again, Judge, we do have some that we're giving him. We do have some video that will probably rebut a lot of the plaintiff's version of these allegations in this case, Your Honor. Also, Your Honor, his housing times he has a renter's insurance from AAA. He's established that claim. I'm sure he has a window she needs to make that claim. So I'm asking the court if we won't consider a personal bond, at least a 10% provision on the current bond.
Response.
Your Honor, I have 2 things. First of all, yes, these are very serious charges. The defendant kept the victim at his home, assaulted her, made her perform sexual acts on him, used her phone to threaten her and her family, also used her phone to take naked pictures of her and video the sexual acts he was forcing her to perform, and then sent it to her family members. In addition to that, from the jail, he decided to call a third party, who I'm sure one of them is health insurance, because he requested that party to contact him and to make sure she did not cooperate. He does have a history, some of it's older, but it's quite extensive. It involves included an alcohol issue in this case. There are drug issues in the past, also risk officers and also crimes, including domestic violence. For all those reasons, and I'm sure there are more, you would ask me to deny.
Anything else, Mr. Brady?
No, other than, Your Honor, we do take issue, and we don't, so the pictures they claim they were sent from the complainant's phone to her current boyfriend. So we obviously take issue with the pictures. I don't think there are any sexual acts or videos related. I don't see that in the discovery. I don't think that's accurate, but they were not sent to the family. They were sent to the current boyfriend from the complainant's phone, which obviously we would think, we're wondering on the timing on those two bills. So obviously there's a lot of he said, she said.
I'm sure the defense counsel will provide you with the videos.
That's
for that.
Motion for bond reduction is denied. Bond will continue. Thank you. Court calls the case of the People versus Lawrence Brown.
Good morning,
AG,
Attorney General Emmanuel Wutsa-Coker on behalf of the people.
Good morning, sir.
Good morning. Good morning, Your Honor.
Mr. Brown?
Yes, good morning, Your Honor.
Good morning. You need a camera.
Okay. Trying to turn it on. Okay, I'm trying to turn it on right now.
It's the one that looks like a camera with a red line through it. There you go. All right. State your name, sir.
Lawrence Brown.
All right. What are we doing on this case?
I tried to reach Mr. Brown yesterday, wasn't able to get a hold of him. I'd asked to adjourn the probable cause conference.
Sheet you're filling in. Sheet. All right. Any objection from the people?
No, Your Honor.
Probable cause conference will be adjourned October 3rd, 2024, 9 a.m. Bond continued. Court does call the case People versus Darnett Blackwell. Do we have any? We have more for the AG.
No.
Sure. Okay.
Ladies and gentlemen, I just had a conversation with the prosecutor in the courtroom. We discussed it on email as well, but I have to on your rate sheets. Let me get an agenda in this file.
And that's not done because why?
My initial note says it's going to be complete, and that's not going to be.
Any objection from the people? Probable cause conference October 3rd, 2024, 9 a.m. Bond continue.
Thank you.
Video one for that too. But we knew Feaster's a little slow. Court calls the case People versus Hassan Akarab. Yeah, I got it close enough, I think.
Please state your name for the record, sir. Thank you, Judge. It's just that the contact with Lonnie is well on its file. Ms. Lonnie indicated that this time she does not have an offer for Mr. Hassan, and so I do have the request of Mr. Hassan.
Do what?
Request of adjournment.
Another one without it.
I did make a record the last time we were here when the defendant was represented by Mr. Von Brown, but it is very likely there will be an amended complaint or information filed in this case. The total restitution amount is now estimated to be in the $145,000. So we are looking at amending it.
Yes, just a moment, but Your Honor, some of my client in the hallway. Honestly, yes.
October 3rd, 2024, 9 a.m. Bond continue. Court calls the case People versus Seth Cope.
So, fortunately, the assistant public defender, on behalf of Mr. Seth Cope. Mr. Cope, please state your name for the record. Your Honor, I have spoken to Mr. Coe. Mr. Coe has 2 files that serve the court. Those files are going to be resolved under the Open Training Act, but the results of waive this matter as well. So this matter will.
Is that correct? Do you want to waive your right to a preliminary examination?
Yes, sir.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. And you understand you will not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right.
We do.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following.
Wait for reading this.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
September 25th at 1:30 before Judge Conlon.
September 25th, 2024, 1:30 for Judge Conlon. Yes. Oh, you want to address mine? Yes, sir.
It's very rare for me to bring this up.
I know.
He's being held right now on a new case that's being reviewed by our office this morning. And I believe it is that would constitute a violation of conditions in this case. As Mr. Feaster pointed out, there are 2 pending cases in circuit court. I believe Mr. Evans is prosecuting him for, among other things, R&O. Anything else? Drug-related charges. And now add this assault-related offense that is being reviewed this morning. I just bring that to the court's attention, so that's appropriate to keep them out of R&O and others in this case.
Anything you want to say regarding that, Mr. Bruce?
Mr. Judge, I can't hold on. It is a few cases at this point. The jury will hold on 4 cases that have been charged. I'm going to have heard about that too. A moment ago, I don't have anything about
You know, just to finish my argument, I have the benefit of Jessica Blanche being here with domestic violence related case being reviewed. The specific request would be to revoke his jail call privilege based on information to her from this investigation.
I don't have any evidence of jail call judge.
Right at this point, and certainly Judge Conlon can look at some of this, but I am going to, given that there is this additional charge and now new assault offense, I will raise the defendant's bond to a $10,000 cash surety bond. I will also, at this time, pending a hearing that may have to take place before Judge Conlon, but on this case, I would revoke the defendant's phone privileges.
Thank you. Thank you, Judge. Yeah, if I could sign the information.
Yes, sir. Case People versus Ahmad Beydoun. Okay.
Judge, we're here for public house conference.
Yes, once again.
There remain a handful of items to review at the police department. They have been flagged to contain contraband, therefore they can't be provided. We have made arrangements to review those tomorrow afternoon. We have an exam day scheduled for next Tuesday. Our request is we set the exam date once for us to finish the discovery process and then discuss applications.
And most of that is true, Your Honor, but as I indicated to counsel before the docket started, I don't believe that an adjournment is necessary and we would oppose an adjournment. The images that are to be reviewed tomorrow are search warrant returns on the defendant's Google Drive. The purpose of that investigation was to determine if there were other victims. This is a case where the defendant met the minor victim on Snapchat, sort of lured her from her home, took her in his car and sexually assaulted her on the campus. Based on the information in the investigation, the detective saw that there may be other victims out there.
So they did a search warrant of his Google Drive, and there are in fact images of women, but they cannot be identified. So I don't think that and obviously we won't know this until tomorrow, until there's an opportunity to do it. But it's nothing germane to the assault on the victim in this case that would require an adjournment. That's a people's decision.
I don't know that that's true until we receive the reports. Two of them, I understand, link Mr. Victim to the thing witness in our case. And that goes beyond just images that are, but there's data of where we have communicated with. I don't know. I don't think I can make sense of those two now.
I have great faith that you actually can. So I'm not going to adjourn the preliminary examination. This matter will proceed to preliminary examination as it had previously been set on the 17th at 9 a.m. before me. Bond will continue. At 9 a.m. examination as it is the preliminary examination this matter will proceed to preliminary examination as it had previously been set on the 17th at 9 a.m. before me. Bond will continue. Court does call the case People versus Timothy Cottenham.
I have Mr. Markel.
Good morning, Your Honor. Good morning to your staff. May it please this most honorable court. Edward Martell, P85051, on behalf of Timothy Cottingham. Sir, please state your full name for the record.
Why do I have Burgess on this? I have Mr. Burgess on this.
I subbed out, Your Honor, Mr. Martel.
That is correct, Judge.
What are we doing?
Judge, we would ask to set this matter for the earliest available examination date, please, and thank you.
All discovery is complete.
Yes, Judge.
People have their witnesses available the 24th. Pardon?
We will do our best.
Preliminary examination in person, September 24th, 2024, 9 a.m. That is before Judge Barr.
Judge, may I briefly readdress the issue of bond?
Briefly.
Thank you, Judge. This matter, essentially, Judge, is a matter where the police were originally the medics were called out, not even the police, Judge. Ultimately, it was determined that some injuries were sustained, Judge. However, the charges do not reflect the actual injuries, nor does it reflect the actual intent, Judge. In light of same, Judge, again, it's our position that the case is overcharged. Essentially, this is a domestic violence where some minimal injuries did occur, Judge. However, Judge, the $1 million bond, Judge, is highly excessive in light of same. These two have a child in common. This young man has no prior felony convictions, Judge. Again, in light of same, we're humbly asking for a $100,000, 10% bond, Judge, which certainly reflects the fact that he has no prior previous history and no prior felony convictions, Judge.
Assuming there's a response.
I believe bond is reasonable based on the circumstances. We did address this last time. These are extremely serious allegations. I think if I'm mistaken, did he just say he had no criminal history?
That's
no felony convictions.
That's what he said to me.
He had
no felony convictions.
Firearms in a vehicle charge.
Excuse me, say that again.
2023, September 7, 2023, loaded firearms in a vehicle charge.
Thank you.
So based on that, based on the fact that, I mean, we've already addressed bond, Judge.
Yes.
Believe it, Judge Barr's discretion, here's the plenary stand to actually establish the facts. And defense counsel doesn't think it's serious, however, it is serious.
And I did address bond at the last hearing. Motion for bond reduction in this matter is denied. You can certainly bring it before Judge Barr at the time of preliminary examination. Bond will continue. Thank you.
Thank you, Judge.
Let's call the case, People versus Alina Bustle.
We'd be asking, I called out for Miss Bustle's name at approximately 9:15, 9:20. She wasn't here. This is the first I know she's here. Ma'am, ask this matter.
No,
Then we'd be asking for an adjournment.
then fill out the form.
Yep, thank you, Your Honor.
Probable cause conference will be adjourned to September 26th. Really? Aye. I don't. Probable cause conference will be adjourned September 26th.
We'd be asking, I called out for Miss Bustle's name at approximately 9:15, 9:20. She wasn't here. This is the first I know she's here. Ma'am, ask this matter.
No,
Then we'd be asking for an adjournment.
then fill out the form.
Yep, thank you, Your Honor.
Probable cause conference will be adjourned to September 26th. Really? Aye. I don't. Probable cause conference will be adjourned September 26th, 2024, 9 a.m. Bond will continue. Now you may go. Court does call the case People versus Benelli Cruz. What I gotta say? Never mind. I'll get it.
Good morning, Your Honor. Rebecca Chiappa, P62311, on behalf of Benelli Cruz.
Your name, ma'am? Thank you. All right, what are we doing?
Your Honor, we are requesting to schedule a preliminary exam at this time.
All discoveries complete?
Yes, I believe so.
Ms. Chiappa, have you come to my office and picked up all the videos? I spoke with Mr. Burgess, who indicated he needed to bring a large hard drive to get them all. Were you able to do that?
I have not, I will do that.
So discovery is not complete. I'm sorry. You know. Oh dear, okay. Why do you say that? What's wrong?
She's not doing that. She's just not really doing what she should.
Okay, let's. Was this a MAC office appointment in this case?
I don't know. I know the PD had a conflict.
Yes.
So it was a PD case. Then you were appointed counsel in the case. Have you met with your attorney? You expressed your displeasure with it? What do you mean?
Like I met her and then I had to tell her. That's all.
Well, did you know it was going to be set for exam today? Okay.
If I may, Your Honor, Mr. Burgess, who represents the co-defendant, is going to request to adjourn the PCC as he has to obtain the remaining videos, which I.
So I don't know why, Ms. Gibbo, you were setting her exam and don't have the videos. I don't get it. Question mark. That's a question.
I'm sorry, Your Honor. I'm confident that I can take a look at the videos. I have the other discovery and will be prepared for the preliminary exam.
Counsel, I get it, and I'm not questioning one's efforts or whatever. But she's charged with aiding and abetting a homicide.
Of course. I would suspect that setting a
Okay,
preliminary
so
exam
I'm just
would
gonna do
would be
this
the
on
next
mine.
step.
I'm gonna grant your motion. Somebody get to the MAC office, tell them I need a new attorney to represent this defendant. Take her back. I'll bring her back out momentarily and we'll figure out what we're gonna do. Okay, Ms. Cruz? You're probably all the way down the hall, you think?
I think so.
Yeah, okay. Court does call the case, People versus Tyler Harlow.
Ready, Your Honor. Arlo,
It's like Fisher started talking like an echo.
Your Honor, seems to, Marcia Creature on behalf of Mr. Harlow, both matters, I sent in.
You're on both matters?
I sent a substitute attorney that signs.
Okay, Fisher, you're out. Your name, sir? All right. And he's waiving his preliminary examination in both of these matters? So you understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? You understand you'll not have that hearing, that you'll proceed to circuit court for further resolution of all of these? All right. People also waive their right.
Yes, Your Honor. Yeah, we are still waiting for one lab analysis in this case. I've let the administrator know that if the lab results come back with a controlled substance, that I will be bringing a new case against him for that. So this waiver does not preclude us from bringing an additional case for the ongoing investigation of this purpose.
That's correct, Your Honor. We could either, we want to get this case going up to circuit court for resolution. I think that both cases are resolved, including the issue that Ms. Hughes has mentioned here. Otherwise.
Right, but depending on the nature of the charge, then the defendant still may be entitled to an exam on that case.
Right, the issue that Ms. Hughes and I discussed is, as we know, the MSP lab time frame as far as getting the test back. We can adjourn in a month to see.
I really don't want to. But I mean, it doesn't matter to me. I mean, what Ms. Hughes is stating, I just have to make sure that the defendant understands that if new charges come, you may have a right to have a preliminary examination on those, or you could waive it. But we're not even covering that in this case. You understand that, young man? All right. So with that understanding, people also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court.
Waive as far as the agreement, waive the reading of the information, and ask the court to allow my client to stand mute.
Defendant every way forward reading standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
October 23rd at 1:30.
October 23rd, 2024, 1:30, Judge Conlon.
Thank you, Your Honor.
Bond in these matters will continue, and yes, Ms. Hughes, I will get the information to you. She asked so nicely. Nimish is rather demanding. Pretrial date, I'm sorry.
October 23rd.
That was before Judge. So, yes, I wrote it and I just can't find it here. Thank you. Court does call the case of the people versus Michael Patterson. Your name, sir?
Michael Lee Patterson.
Thank you.
Your Honor, I have been discussing this matter with Mr. Patterson. We're having one adjournment for further discussion. I have just been aware of your new system component, so I'm working on that.
Not new. This is a whole week. You should know. How much time did you need?
2 weeks, Your Honor.
October 3rd, 2024, 9 a.m. bond continued.
And Your Honor, may we discuss that? Not to remind this case or anything, does have to do with the iPhone. And Mr. Patterson is happy for our bonds, so then he continues to deploy that. And he does have a birthday.
That's right.
I have a PR bond on this case.
You do have a PR bond in this case?
Yes, Your Honor, that's correct. There is PR in this case. There's another case in Fulton.
Okay, excuse me, Your Honor.
That's okay. You did a Chinaza and really bond argument.
Okay.
I didn't have to do anything. His bond continues. Thank you. You have a very strange definition of success, but fine. No, you take the win when you can get it, right? Court calls the case, People versus Clinton Berry. Good morning, Mr. Vincent. How are you, sir? Okay.
But good otherwise.
Good. You're requesting adjournment. Your form is filled out and everything, and you did not write this. No, never mind. I just know you didn't because I can read it. Any? Pardon? Okay. As to the adjournment, people, any objection? Public class conference, will October 3rd work for Mr. Vincent? Thank you. October 3rd, 2024, 9 a.m. As to bond.
He's currently testing. He's a truck driver. He's out of state. I talked to him last night in Indiana. He would like to be able to use soberly rather than a tether. So he takes his device with them and check in. If sometimes out of state and he can't go in practice.
Well, I'm trying to figure, what's he on a scram?
Done a GPS tether, and I believe done, we had to test twice a week, twice a month, I'm sorry.
For drugs.
I think it's probably alcohol. It's making something for everything.
That's probably true. So I guess I'm trying to be clear on what you're specifically asking for. You want him put on a sober link to do what? To test for alcohol?
Going through the report, I didn't see a mention of drugs. I didn't see a mention of alcohol.
He tests how often?
Twice a month.
So you want me to change his bond conditions from testing twice a month to blowing into a machine 3 times a day?
That's 2 months. Problem is he doesn't want to violate. He's frequently called to Kentucky, out of Michigan, miles out of Michigan. Can't get back to test. If it could be arranged that he can get back to Michigan, we'll go test.
Well, I don't know that it can work that way. I mean, I if he wants to blow into machine 3 times a day, he can have at it. I just think that's probably more of a problem for him, but Because if he misses a test, that's a violation.
Your Honor, my client will speak to me first. Your Honor.
You're withdrawing your request. Yes, good. Okay, bond continued. Thank you.
Get the GPS test.
Yes, he'll have that.
What did that happen?
Denied. You will have the GPS data. I don't know, it was so long ago. October 3rd.
Thank you.
Thank you, sir. You're seeing you is my pleasure. Court calls the case, People versus Jabari Holmes. Dear God. I mean, woo-hoo.
Good morning, Your Honor. Christina Costantino, appearing with and on behalf of Mr. Holmes. Mr. Holmes, please state your name for the record.
Thank you.
Your Honor, this is the text that for you. I have just been appointed today on this matter, so I would be asking for an adjournment of the BCC so I can obtain all the necessary discovery.
All right, you want 2 or 3 weeks?
So if we could do 3 weeks so I can ensure I have all the videos, that would be.
Gotcha. Probable cause, October 3rd, 2024, 9 a.m. Bond in this matter will continue. Thank you, sir.
Could I address bond?
Absolutely.
Thank you, Your Honor. It's my understanding my client's bond is currently set at $75,000 with no 10% provision. We are asking for the court to consider at least a 10% provision or a reduction in bond. He's 29 years old. He's currently employed full-time at Enterprise, where he is a general manager. His employment is in the nature of managing data portfolios, and he's worked in that capacity for the last 2 years. He does have 2 children that he provides support for and takes care of on a regular basis for young children. He does reside in the Ann Arbor area. It's my understanding that I don't believe he has any history in about the last 10 years or so. So we would ask for a reduction of bond. We can follow any and all no contact order, and a GPS tether could be imposed should the court have concerns about his whereabouts.
Response.
I'm very thankful that he's a history of the past 10 years because he was on parole for home invasion until 2021. So he's otherwise been law abiding, but he was under NBC's jurisdiction. His criminal history has counted at least 6 home invasion cases while I've been sitting here, but he does have prior invasion. His bond is 75,000 cash surety. However, I'm requesting 250,000 cash surety, which is the initial bond request that my office states. He does also have goals. He has a bond denial in Trenton for a visa. So if we were to release him here, we would release him to wherever Trenton is.
Really? How long have you lived in the state? Never mind. That was that whole Canadian thing coming back. Go ahead. I'm sorry, Miss Hughes.
Former how close Trenton is to Canada?
Very close.
I think it's South Canada. Go ahead.
So in this case, he broke into a home while 3 family members were upstairs sleeping. While he was in their home, while they were sleeping, he stole numerous items from their home, including a laptop that was cracking. Victims woke up, discovered that they had been robbed while they were victimized in their own home. He had the laptop, the police then took over the investigation, were able to link the laptop directly to the defendant's whereabouts. Again, Your Honor, I'm now requesting 250 cash surety, which is the request we've made from the time we charged this case. Thank you.
Your Honor, I strongly believe $250,000 bond or any bond increase is not appropriate. I understand the nature of the facts. However, even if the facts as the people state them are true, which we dispute that he's innocent, but even if they are true, there wasn't anything assaulted mentioned in that series of alleged facts.
Because they didn't wake up. Never mind. You don't have to worry about that. They didn't allegedly. All
Allegedly,
right.
Your Honor. And
I won't raise the bond, but I'm not lowering the bond. Motion for bond reductions tonight.
Thank you, Judge.
Thank you. Courthouse case, People versus Leroy Fedorko.
Caroline Foster, Sunrise.
Your name? You're requesting an adjournment
Yes, Your Honor.
to review this.
I'd like to address that.
Okay.
Obviously, the defendant is out of custody. This is a domestic violence case where he poured bleach onto her. She's hit with a chair and her left arm is head. However, there's more investigation going on based on the fact that she went to the hospital that evening. We have Washington County now taking over the case and investigating it further. My concern is that.
Who was investigating it initially?
It's Lanny.
Okay.
So there are gonna be higher charges being brought against this defendant, I believe, but he's contacting the victim, and I have text messages I sent to the PD's office for the case. So I'm asking you to remove the bond today, based on the fact that we had asked for a higher bond in this case, and the $5,000 cash surety bond was ordered to begin with. So I'm concerned the minute he got out of custody, he started contacting the victim on text messages.
Any response, counsel?
No, I honestly don't have any evidence or discovery of those alleged violations.
You said there were text messages that were sent to the.
The defender's office, I believe it was Mr. Gaddy was on it originally, and he said he was off the case. I didn't know who was on it.
Got it.
We just jumped in yesterday. So we have not received any of these collaborations.
So let me just, here's what I'm hearing, that there may be higher charges coming because in part the use of bleach on the defendant.
No, well,
Or-
she was sent to the hospital and more allegations came out.
Got it.
So now there's gonna be, I'm pretty confident there's gonna be more charges added in this case.
Got it. And then the other thing is that since the time of his release, the people's allegation is that he's been violating the condition of his release by contacting the victim in this case. All right, you don't have that information, counsel, before you at this point. All right, what I'm gonna do, defendant's remanded to the jail. We will bring him out. We will let you see that information, so at least you can make a preliminary argument, and I'll pass the matter. Defendant's remanded. They need to hold him up, because when she gets, they need to keep him up here, so when she gets this kind of. Court does call the case, People versus Jonathan Lilly.
Ready, Your Honor.
Andrew Childers appearing on behalf of the people.
The first. Yeah, the defendant has been
I was confident in the name. Go ahead. You see,
He's executed.
he's in custody? Where is he?
Lily.
Oh, he is. You got him? Okay.
Bus related.
Yeah, I guess that was because he went back, so I thought we were doing that.
State your name.
All right. All right, what are we doing?
Your Honor, today is the date and time set for continued probable cause counts. We'd like to set this matter for an exam.
All discovery is complete?
Yes.
People have their witnesses available the 24th.
That should be fun.
Preliminary examination in person will be set September 24th, 2024, 9 a.m. That is before Judge Washington.
Is it in this building?
Pardon?
It's still in this building. correct?
Absolutely.
Your Honor, can you put our exam towards the end of the, and I get a right to do that with Judge Washington?
So when you came in, there was a menu, right? And so you're able to like order stuff off of that? I just assigned this to Judge Washington. If you want it near the end, or however that happens, you need to get to Judge Washington.
Your Honor,
And when you ask her that, let me know what she says. Go ahead, what?
Your Honor, one other matter, which is the matter of bond at this time, my client has no bond set. And he's been in the jail for nearly a month. He was out on bond. He was complying with everything. There was the standing about testing.
Yeah, so he wasn't complying, but go ahead.
Yes, so he misunderstood about the testing. After speaking with me, understood that he needed to continue testing. He did come in on his own to test, and he told the testing people that there was a link for his arrest. So he was very open and honest, Your Honor, and trying to be fully compliant. He has no criminal history. And Your Honor, in this matter, the victim herself had alcohol and multiple drugs in her system and was not wearing a seatbelt, so on. So Your Honor, I would ask that you consider reinstating this previous bond.
Your Honor, in this case, the defendant was traveling in excess of 100 miles an hour at that time, when he crashed into his car. So,
Your Honor, we dispute the speed.
not from a crash in reconstruction, it's the vehicle data.
Yeah, Your Honor, the police report says 86, but
Oh, 86 as opposed to 100.
it is lower. Your Honor, he's been abiding by everything else. We'll be doing the testing.
He missed 4 successive tests. The test before that had an abnormal creatinine level. Test before that was, you want me to go through it? Because we've been through all of this, Ms. Celso. Motion for bond, or your request for bond reduction is denied. Bond will continue, and you'll continue on to preliminary examination before Judge Washington. Court does call the case of the people versus Jamal Gardner.
Just a land here and that people.
A couple of things. I was just to point out a matter. I wonder if we should have 2 weeks.
2 weeks, you need to keep your hand out of your pocket. Okay, thanks. All right. You fill out form? No.
Should be, it should be in the bond.
He did? Oh, never mind. I just don't have it.
Oh,
Just-
what's
that's
the
okay.
name?
Gardner. All right. You need 2 weeks? Any objection from the people? September 26, 2024, 9 a.m. Bond continue.
Can I address the no contact vote?
You may.
Alleged victim in this matter is here. They have 7 days who are here, very young, including 16-day-old baby. I believe the mom, if you were to ask, is asking for no non-consensual contract.
Have they talked to the victim's advocate?
They have.
All right.
She's here, if the court would like to hear from her, but having 7 kids, she really needs the help. Again, I'm not minimizing the sense at all, but that being said,
Do the people have a position?
Judge, normally we ask for the no, I think it should stay in place based on the fact that there should be cooling off period. The victim does want to have contact with him, though. So the court is going to change and ask for contact. I'm more honestly, we have police witnesses in this case where he kicked the windows of the police car and broke them and a couple of RNOs. So that's really the driving force of this charge. Is not the domestic violence. Obviously, they were called for domestic violence incident, but the driving nature of felonies. So we will have those witnesses here.
Where is she? Still can't see you. Okay. Yes, you got babies back there. That's why I'm not having you come up. Your name, ma'am? All right. And what's your, would you like no non-consensual contact, ma'am?
I do not want, I want him back home. We have a 16-day old baby. He hasn't even hardly seen. So, and I have 7 children. He needs to be at home.
Okay.
Thank you, Your Honor.
Thank you, ma'am. All right, here's what I'm gonna do. We probably have 2 restrictions because he's not. The Apple Ridge is the home address. And ma'am, what was your name? Thank you. So, okay, here's what I'm gonna do. We're gonna do it the simple way because of the way that they. To do it, the order, the original release order, so that I'm clear, indicates no contact with Tova Taylor, no go to the Ypsilanti Township address. And also, although the box isn't checked, it does have provisions of no go to homework, school, or house of worship of Tova Taylor. However, that's not checked. The court's going to change those provisions. I'm deleting the no contact and the no go to provision. That would be inclusive of the last provision that I just read off, which is where the box is not checked. So, and then I'm going to add a condition of no non-consensual contact with Tova Taylor. So in that respect, defendant's bond motion is granted. We'll see you September 26, 9 a.m. Bond. Pardon?
That's changed.
Okay, so Mr. Kilwald, why would I change the no contact and then say, well, you can't go to where everybody else is?
That's why
Yeah, okay. I thought I made it clear, didn't I?
it was my fault.
I know.
Thank you.
Okay, thank you. All right. Thank you, sir. Court calls the case People versus Kristen Lucas.
Okay. Marshall Creature, on behalf of Ms. Lucas.
You're requesting an adjournment.
Yes, we are, Your Honor. Request, 2 or 3 weeks. Possibly requesting, if possible, another 5 days release to inpatient treatment.
Probable cause conference, October 3rd, 2024, 9 a.m. Any objection to release to inpatient?
Reluctance. This is definitely somebody who needs drug treatment. However, the allegations against her are so serious that she's also somebody that should be in custody and is looking at a prison.
Got it.
Um,
Well, here's what I'll do. I'll just stop it right here. If you would like that provision added, that I'm going to deny it at this time, you'll have to file a written motion with the court so the court can look at it. Thank you.
Your Honor. Thank you very much.
Let's call the case People versus Maurice Anthony. Maurice Anthony.
Assistant Public Defender, Anthony, not sure if he is here. Not sure, so, Your Honor. I don't know why he is not present. I know this, my wife, that her great sheet, Your Honor.
She's saying he's gonna hire an attorney, so that means she must have talked to him when he's here. So where is he?
Judge is here.
Oh.
Meet for my answer. Assistant Public Defender, Sarah White, on behalf of Maurice Anthony.
I have a form indicating he's seeking to hire an attorney.
Yes, Your Honor, he has been, he was looking, and he had to have cancer, he put everything at off. So he's asking for more time, is my understanding.
How much time does he need to do that? Without objection, I'll adjourn the probable cause to October 3rd, 2024, 9 a.m. I'm sure that your new counsel will inform you to waive full dress trousers before. Thank you. Bond continued.
Thank you.
Court calls case of the People versus Linnell Pickett.
We don't need these on this.
Good morning, Madam. Please solemnly report David Burgess on behalf of Mr. Pickett, who's standing to my right. Judge, we addressed this earlier, you addressed this earlier with both the co-defendant. There's some discovery that's outstanding. Our office needed to get
The co-defendant was Cruz.
correct.
Okay.
So same issue, Judge. We're requesting a 2-week adjournment.
2 weeks will do it for you
Yes,
for looking.
ready to set the exam, but then I should have plenty of time.
All right. Have they gotten me a new attorney?
It's crazy. Yeah, she is, she's great. I'm waiting for the order.
I just,
Okay, so Ms. Critter, Ms. Cruz isn't out here. If I adjourn this out 2 weeks, is that gonna be enough time, you think, to go through discovery and get to her?
Yes, sure.
All right.
I will endeavor. Like today.
Probable cause here will then be adjourned to September in the Pickett matter, September 26, 2024, 9 a.m. Bond continue this time. Thank you, sir.
I'll require signature and.
That's it. Okay.
Those are passed.
Court does call the case of the People versus Alexis Archer.
This file went off without.
It's on this one. Okay. Okay. Get Miss White in here if this is her case. This is the third case of hers where she's not been in here. Ma'am, do me a favor, have a seat. We'll get you right back up as soon as they can. Or does, who do they have? I don't have any custody.
Should have.
Who do you have?
Is that Reed?
Reed, oh, it's just the thing fell off, okay. Rayvon Reed, Saxon,
But I think she could do those markings. Oh, I'm sorry.
I have Saxon on this one, did she,
Oh, I'm sorry, no.
okay, where's Miss Saxon? Your name, sir? Thank you.
Case number 24.
Yes, ma'am. All right, what are we doing? I'm sorry? For
I'm sorry.
all discovery is complete?
She said she had. It is available, but I just confirmed, she said she sent me an email, I did get an email, so that I confirmed with, our LAs to see if she's requested it, they don't have a request yet, so you just need to make sure you put it through PA Discovery so you get it in time.
I do. Okay, I'll do it.
Okay, well, hold on, you don't have discovery, so how can I set an exam? So you gotta get discovery.
Forgive me for not being acquainted with your procedures, Your Honor, as you know, I'm not here. Normally, if the prosecutor says we can get it to you in a day or two, that's well before the date, that gives them time to review.
That's not how we do it, and you know that, Ms. Saxon, so you can go ahead with that explanation if you want, but that's not how we do it. When are you gonna get the discovery?
I need the prosecutor to answer that. I sent a reply email with this link.
Tell you what, here's what we'll do. We'll just, you guys sort it all out. Sir, I'm gonna adjourn your case 1 week. Okay, just 1 week out. Let them get everything together and we can get it set. All right, understood. Probable cause conference, what is 1 week out? 19th. During this September 19th, 2024, 9 a.m. Bond continues. Okay, yeah, she's gonna need something. I don't know. Alexis Archer. Ma'am, what is your name? All right, what are we doing?
Your Honor, I have one adjourned so that I can speak further with the prosecutor.
Get a sheet to us. Get probable cause conference, October 3rd, 2024. She's got one.
They have Miss Cruz. I have that order.
They have Cruz up there. Court recalls case of people versus.
Good morning, I'm Marcia Fisher on behalf of Ms. Cruz. Thank you, Your Honor, for that brief. I will be requesting an adjournment of PCC to confirm with the.
Okay, so 2 weeks out.
Yes, please.
All right. And Ms. Cruz, while you weren't in the room while I was adjourning the other case, I checked with Ms. Crater to make sure that that was okay. So that was something that occurred out of your presence. I wanted you to know that, okay? September 26, 2024, 9 a.m. bond will continue, and I'm sure Ms. Creature will be down to see you and everything. Okay? Thank you. Court calls the case People versus Michael Bailey.
Zoom by chance? I do not have him check them.
No.
Your Honor, I did make efforts to contact Mr. Bailey prior to the court date. I did not receive a response. I did email Zoom link. I think previously appeared to be Zoom.
Where are my other ones?
I would ask for it.
Where am I? Never mind. I got it. Bench warrant will issue for defendant's failure to appear bond 10,000 cash surety. That will issue immediately. Because I guess technically they were asking. Court does call the case People versus Sheena Stout. All three cases.
Andrew Tilden, appearing on behalf of the people. Better luck, yeah, this is involved.
I have you on two matters.
Three cases of the two I have.
Oh, okay. I'm sorry. I thought when I checked, one hadn't been arranged.
I think both of the ones that the PD have ending in 5224 and 5225, those have both been arranged.
Your Honor, Marcia Frazier on behalf of Ms. Stout in 5231.
I'm sorry, Your Honor.
You guys are requesting an adjournment in any event, right?
Exactly, yes.
Yes, Your Honor, I do have the appropriate
Forms filled out. All right, how much time are you gonna need?
Your Honor, speaking of my client, we would like to make a referral for mitigation social work, so 2 or 3 weeks. And further, my client is asking for a release to some treatment, inpatient treatment to Dawn Farm during this time period, if that would be possible.
Well, is she in the program at all, or, I mean, how?
No, she is in no program, Your Honor.
So she would need to be assessed.
Right, she's not been assessed, is it?
That's correct. We just started this process.
Okay, well, I'm not gonna release her. I don't know if that's a request for me to modify her. I'm not gonna do anything at this point.
Your Honor, I know it appears to Ms. Stout may have other matters on the jurisdiction. So my house may be. Taking, I think she probably.
Got it. Okay. What I'm gonna do is I'll adjourn our probable cause conference October 3rd, 2024. Bond in all of these matters will continue. They get that information and assessment, then we'll take a look at release to that.
Yes, and so the court's aware that referral request has been made already today.
For the mitigation.
Yes.
For the mitigation, but not for
Not for the drug.
Correct.
October 3rd, 2024, 9 a.m. Bond continue. Yes, he'll Court does call the case People versus Emily Bates. Okay.
Andrew Tilden, appearing on behalf of the people.
Emily Bates.
All right.
Good morning.
Thank you. Good morning. You're requesting an adjournment to get treatment records. How much time? About 3 weeks? Turn this to October 3rd. 2024, 9 a.m. bond continued.
Thank you very much.
Thank you. All right. Thank you, Ms. Bates.
Thank you, Ron.
Court does call the case, People versus Daryl Frederick, all 3 cases. Your name, sir. Good morning. Okay, folks, this is Miss White's case again. Somebody else in the PD step up. She's asking for an adjournment to review. I don't have all day to wait for her. Somebody's gonna need to explain that to her.
Kevin Overwater, Assistant Public Defender, standing in.
Your name, sir, again. See, there have been a request for an adjournment to review videos filed by the defense. I'll grant that. Hopefully it can be done in a couple weeks so that the gentleman's case can proceed. September 26, 2024, 9 a.m. bond will continue in this case. Thank you. Missing. Need to be done. Court does call the case of People versus Ronald Blackman.
Actually, like the people.
Your name, sir?
This is what the defender Hannah Apple stating in.
I have a request that we're requesting an adjournment. Because they haven't had contact with them.
Thank you. Your Honor, we would ask that I'll make sure. Contact information.
Probable cause conference, October 3rd, 2024, 9 a.m. Bond continued. Thank you. Court does call the case People versus Stephen Hensel.
Assistant Public Defender, Jane Oldroyd, on behalf of Mr. Hensel. Okay.
What is that?
This is for your.
I changed my mind, I'd like to actually do the pre-trial.
Okay. Yeah. I'm sorry.
Yeah, we all heard.
Okay.
So he wishes to have his freedom.
Sounds like.
And I'd like to tell the court that I'm going to. It's my personal belief that I've been suffering severe neglect in the care of the police here. So what I'd like to say is I am neurodivergent. I am prone to outbursts when triggered. That can result in vulgar stuff, things that are very out of character, things that trigger me are being overwhelmed by the overwhelming force, having more than one person come at me at once, people giving me authoritative commands, things like that. But not once have I been suicidal since I've been here. I was interpreted as suicidal both times that I was at the police station. They put me inside of conditions that are extremely inhumane. Not once did I mention that at the hospital, the first time I was brought in. Despite this, I was treated as a suicide risk both times, I think that's what treatment on my part. They left me under 24/7 lights. Fluorescent lights, about as bright as this, and all I had was a jacket to cover my face. I have sensitivity issues. I wasn't able to sleep for the first 5 days that I was here. I asked for a shower. I didn't get one until day 5. I was asking regularly, but walking by were unable to, they were dismissive. The phones were non-functional. So that was kept in the first two, but the buttons work, you can turn it on, but once you get through the commands, it doesn't allow you to dial out. So I was unable to actually call anybody for a few days. When you get into the main part of the prison, there's a jail. There's the group of phones we turn on and off. The only one that works is the one farther away from the desk. And when you dial out, you're not able to always use the face. I believe that I was denied the ability to communicate with people, and that's led to confusion, inability to protect myself in the case. There was no blanket provided to me, so all I had was my jacket to cover my head, and like I said, I couldn't sleep. I was transferred to maximum security cell for no apparent reason. Urine was covering the walls when I got there. That took me 40 minutes to clean that up. And that's a block of wads of paper, so leaving me to believe that I could suffocate in there. I scratched it all off, but it was all toilet paper craft from my vent. The inmates have been intimidating. The man below me practices stabbing while I'm there. So what I hear during my time, I get 1 hour out. The rest of the band hearing down below, and the rest. You get the other inmates screaming, faggot, kill yourself, for an entire hour. We had somebody show up, and for an entire hour, they were playing the bass drum by thinking there's more. And so the conditions that I'm living in right now.
Excuse me, sir. What would you wish me to do?
I'm just putting this on.
Okay. Are you almost done?
The laundry was collected.
Are you almost done?
Yes. The laundry was collected. The temperature dropped by 10 degrees, and if I hadn't saved my blanket, it would have been extremely unbearable. There are torturous things going on in this place. I think that there's induced suicide happening, or at least the attempt to. I am serious that this. I've been trying to call my dad. It was his birthday yesterday. I called him 3 times, and he wasn't able to pick up the phone. We've been trying to get that to work. That's about all I've got to say, and I'm familiar with you.
Thank you. All right, Mr. Bellinger, what would you like to do?
Second, please.
Well, discovery complete, sir.
You're very arbitrary.
Thank you. You're welcome. Discovery is complete. People have their witnesses available the 24th.
Police officers will do our best, Your Honor, but I have been contacted with them about their availability.
All right. Preliminary examination in person, September 24th, 2024, 9 a.m. before Judge Barr.
Any further treatment, if I'm left in this condition, I'm going to.
Bond will continue. Thank you. Court calls case, People versus Raymond Bowman.
Saw that gentleman walking up. We shot Mr. Bowman, my phone checks, everything around, had no contact with his phone, not like that.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Thank you. Calls the case, People versus Trenton Johnson.
Jessica Blanche Grant, phone. Since the public defendant is not authorizing that to threaten Johnson.
Your name, sir? Thank you. What are we doing?
Your Honor, we'll be asking for an adjournment.
Do you have a form
Segment.
on Johnson? What's the basis for the adjournment? All discovery complete.
It should be, I think there's a media notice, as long as she got that one, the extra one that was discovered, it looked like it had been sent out.
It hasn't been sent out?
Yeah, but it's discovered, so it shouldn't, they should have released it by now, I think. This is from 10. Yeah. There's media.
Okay, can we ask for at least 1 week adjournment?
Probable cause conference out 1 week, September 19th, 2024, 9 a.m. Bond continued.
Thank you.
Court calls the case, People versus Casey Boyd. Okay, thank you.
Wasn't sure if we didn't reach the judge, what's up, contact Mr. Boyd by phone, and the phone was disconnected. So we're asking for adjournment.
Any objection from the people? I'll adjourn this probable cause conference October 3rd. I work for you, 2024, 9 a.m. All right. Keep in touch with your attorney. Thank you. His phone's working. Feaster, you called the wrong number, didn't you? He called the wrong number, tried to call the man out. His phone's working. Never mind. All right, you guys figure that out. All right, thank you, sir. Court calls the case, People versus Jacqueline Jones, Washington.
No voter assistant public defender on behalf of Ms. Jones, Washington.
Your name? Thank you. What are we doing?
Competency was raised yesterday on a misdemeanor matter, and we're doing the same on these cases.
All right. I don't have any orders. You'll get back to us. Forensic evaluation is ordered. I'll set a competency hearing for December 5th, 2024, 9 a.m. Thank you. Bond will continue. Case, People versus Carla Bird.
Assistant Public Defender Greg Long on behalf of Ms. Bird to approaches. Ms. Bird, please take it for the record.
Thank you. You sent mitigation information.
I did, Your Honor. We were just asking for the adjournment for negotiations.
Mr. Bowman sent a very extensive and detailed email to me. Thank you.
Okay. Probable cause conference will be adjourned October 3rd, 2024, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls case, People versus, is it Princeton Earl Jones?
And that's a lot of people.
Your name, sir? Thank you. All right, what are we doing?
Yeah, I did have a chance to meet with Mr. Jones, and I had a chance to discuss this matter with Ms. Blondie. I'd ask the court to adjourn the probable cause for a couple of weeks so that we can investigate potential treatment as a potential alternative for Mr. Jones.
Got it. October 3rd, 2024, 9 a.m. Continue.
Thank you.
Thank you. Let's call the case of the people versus Glenn DeMason.
Mason's approaching. Mr. DeMason, please state your name. State your name. My name is Glenn DeMason.
First.
Yes, Your Honor, I did speak with him regarding that. Mr. DeMason was not aware that he needed to be testing. I did instruct him to go to community corrections. He reports that he went there this morning and he was told to come here. So here he is. He will go there. If the court's willing to allow him to remain on bond, he will report directly to community corrections.
What are we doing on the case today?
Yes, going to set the matter for preliminary examination.
Sir, if you were tested, you test clean today?
Yes.
I'll need a new order, but gonna go over and test today, and then I'll reinstate the previous testing order of 1 time per week. But he's to test today. And I'll sign an order to that effect. I'll set this for a preliminary examination. All discovery is complete.
I know.
People had their witnesses available the 24th. Preliminary examination in person, September 24, 2024, 9 a.m. before Judge Washington.
Thank you.
Bound will continue. Thank you.